Yeah, it's on. Okay.
All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please come to order.
Thank you. Good morning. We have 3 cases on our calendar this morning, and we'll take them in the order in which they appear. The first case is CR CALDERON Construction Incorporated versus GRUNLEY Construction Company. Counsel, you may proceed.
Good morning, Your Honor. Leonard Sachs on behalf of CR CALDERON Construction, the appellant. May it please the court. The parties to this dispute involved CR CALDERON, a subcontractor to GRUNLEY Construction, the appellee, on a project, Gate project owned by Euro Capital. The parties entered into, there were disputes and differences between the parties, and they entered into an agreement to arbitrate the dispute. The dispute was arbitrated, and a decision was rendered in favor of GRUNLEY and Euro. Euro was then, by the lower court's order, taken out of the proceeding, and the real party in interest being GRUNLEY Construction. Appeals were noted to the lower court in an effort to vacate the award. The 3 issues that were raised to vacate the award was the failure of arbitrator Shapiro, the arbitrator selected by GRUNLEY pursuant to the terms of the agreement, the issue of whether or not the arbitrators properly ruled on the question of damages, and as a result of the breach, as well as the arbitrator's ruling awarding GRUNLEY attorney's fees. Essentially, this comes down to the request by the appellant for this court to review and provide direction, specifically starting with the Uniform Arbitration Act adopted by the District of Columbia, specifically Section 164412A. The provision, and this was a change in the code, the regulations applicable to arbitration proceedings. It is our contention that the statement in the change that made an arbitrator's disclosure mandatory, he shall disclose prior to the onset of the proceedings any and all interest, and that disclosure requirement is to the parties.
Mr. Sachs, I don't think it says any or all interest. I mean, there is a mandatory disclosure requirement, but it has some qualifications on it. And so it's, prior relationship and interest that I'm paraphrasing here would cause a reasonable person to, or a reasonable person might think would affect impartiality.
Apologize if I overstated it, but I'm going to try to parse it and explain the basis for that statement.
Before you get into the weeds of it, can I ask you a framework question? Because your opponent argues, as far as standard review goes, your opening brief kind of has a somewhat generic questions of fact are reviewed for clear error, questions of law are reviewed de novo. Your opponent argues that the trial court's determination of things like, whether a reasonable person would consider the non-disclosed information here to be likely to affect impartiality, that's a ruling that we are required to defer to. It's kind of an abuse of discretion deferential review of that determination. I didn't see a response to that in your reply brief. Do you dispute that? Do you think we are just kind of ourselves supposed to decide that question de novo, or do you think we should be saying, well, the trial court concluded that, and we need to figure out whether that was kind of a reasonable conclusion to which we will defer if it was reasonable.
That is what I was referring to, Your Honor, as the reasonable thread. The question is whether or not the determination and the exercise of discretion was proper or improper. The exercise of discretion is reviewable, albeit under very strict standards. And what we're requesting is that before you get to the question of whether or not there was a proper exercise of discretion, we believe that you must apply, or not that you must, clearly I'm not dictating, but that 4412A must be read in conjunction with subparagraph E that states there's a presumption to act with evident partiality. So one of the problems that we really are asking the court is that without disclosure, you don't have a reasonable person standard to apply. If the parties were arguing over whether or not the disclosure would result in partiality, is really not the question in this case, because it is stipulated there's no disclosure. And the one thing that the lower court failed to do is connect the failure to disclose with the presumption of evident partiality immediately upon the failure of the disclosure.
Mr. Sachs, your opponent, I'm interested in your response to another argument your opponent makes. Your opponent argues, as one of a number of points your opponent makes, that there's an inconsistency between the position that you are taking with respect to Mr. Shapiro and what he ought to have disclosed, and with the failure of Mr. Pike to disclose comparable information. And that, if your argument about what Mr. Shapiro was required to disclose is correct, then Mr. Pike failed to disclose a lot that he ought to have disclosed. I didn't see a response to that in your reply brief, so I am interested in your response to that argument.
My response is very simple, is that if they had raised that issue, they would be in the same position we are. And the fact that they're using that as a measure of conduct is a totally inappropriate standard. The question—
Well, maybe I should simplify my question a little bit, because do you agree that under the standards that you say apply and require Mr. Shapiro to disclose, that Mr. Pike was required to disclose things that he did not disclose? Do you agree with that?
Yeah.
You do? Okay.
Yeah.
Thank you.
And I think that in that event, the same standards that I'm requesting the court to apply would and should be applied to Mr. Pike, if that was the case.
Mr. Sachs, I'd like to ask you a factual question.
Yes, Your Honor.
Around page 400 of the appendix is a series of emails which talks about the need to find a substitute arbitrator and the designation of Mr. Shapiro. Right in the middle of those emails is a copy of Mr. Shapiro's resume. Was that resume disclosed at the time of his designation?
I do not recall receiving one, Your Honor, and I don't recall it.
A further question. Do you think every failure to disclose as required by subsection A triggers the presumption of partiality described in subsection E?
Yes, Your Honor. That is our position. But the
language of subsection E is markedly different than the language of subsection A. So I'd like you to explain why you take that position.
Well, at the end of subsection, the evident partiality, that refers back to A. And as far as we are, if at the end, an arbitrator appointed as the neutral who does not disclose a known direct and material interest in the outcome of the arbitration or a known or existing substantial.
Right.
I'm sorry.
That language is different than reasonable person and likely to affect. So that leads me to wonder whether a violation of subsection A triggers the presumption described in subsection E.
If it doesn't, then, Your Honor, as far as we're concerned, the change in the law was totally ineffective, which is why this case is before you, is that there was a purposeful change to ensure that the arbitrator, the one possessing and the only one possessing the knowledge, has to disclose that information.
Excuse me, legislators make changes through language they enact. So we've been taught to pay attention to the words of the new statute, and that's what I'm trying to get you to do.
And I thought I was, but I will give it a shot again, which is the initial burden under A is for the arbitrator to make a disclosure. Without that disclosure, there is no reasonable person standard to determine whether or not the disclosure was or should be challenged in any way, shape, or form. And
leaving aside for a minute the language, you also are making an argument that if the statute is construed so that not every violation of A triggers the presumption in E, then the statute is a nullity and makes no sense. And I'm not sure I follow that point either. One way of looking about how A, D, and E fit together is that A requires disclosure of certain things. If that is violated, D tells you that an arbitrator may set the arbitral award aside in the arbitrator's discretion. E tells you to a narrower class of things. If what was disclosed, what was not disclosed is, significant, it is substantial, it is present rather than past, then a presumption of evident partiality arises, and presumably and then unless that presumption is rebutted, the arbitral award would have to be set aside. That seems like it makes a very, it's a very logically structured. I mean, it's not the only way to do it, but it seems like it makes perfect sense and doesn't make anything a nullity. Is there something wrong with that way of looking at the statute?
In my opinion, having done this, my issue and the reason we believe the lower court was wrong is that you are putting the construction of the statute goes back to the old standard, that being that the person not responsible for any disclosure must locate, find a disclosure, and determine evident partiality and the entire concept. What you've done is said, okay, first demonstrate that this non-disclosure, whatever it was, you don't know at the time, qualifies as being something that may influence the outcome or demonstrate bias. That's essentially not changing anything. You're asking the appellate to come up with evidence, and not only come up with the evidence, but now demonstrate that that evidence would or might impact the arbitrator's determination and demonstrate that it might be biased. Those standards are so beyond any normal person's ability in an arbitration, and it shifts the burden to the appellant after the proceedings to come up with actions without an evidentiary proceeding. The burden is almost an impossible burden to fulfill, and nothing for the reviewing court, such as yourselves, to determine, to make a subjective or make an objective determination based on no information, no evidence in the file, and say that the appellant did not carry its burden to demonstrate bias makes the new statute be governed by the old standards. And
Mr. Sachs, may I ask you, when after the arbitration, your side learned about the arbitrator, Mr. Shapiro's relationships, would you have had the opportunity to ask the court for leave to take his deposition or to take other discovery to explore the nature of those relationships?
we did request the court for a hearing, and the court did not grant a hearing. And we are also under these pleadings saying that it should be reversed so that.
Was it an evidentiary hearing that you requested? I was under the impression that the briefs were filed. The court found the briefs very thorough and substantive and did not see the need for oral argument.
We did not request that I recall a separate hearing for the court to call in the parties that offered declarations.
Do you think that that you would have been entitled, given the showing you had made, that you would have been entitled to depose the arbitrator, Mr. Shapiro, or possibly take other discovery to fill in the gaps and establish your case?
On the limited issue of the alleged conflicts with respect to that, yes, not as to the determinations as to the outcome of the award, which is why one of the issues we have raised to this court that we believe.
I'm sorry, I was referring only to the issue of the arbitrator's disqualification.
Yes, Your Honor.
Because right now, we don't really have a lot of information. We have only what what parties were able to glean or put in the record from third-party sources.
That's
similarly,
exactly.
including the deposition of Mr. GRUNLEY. Excuse me, not deposition, the affidavit of Mr. GRUNLEY. May I ask you a question about your interpretation of subsection A of DC Code Section 1644.12? I'm wondering if you agree or disagree with the way the trial judge, Judge Epstein, interpreted it. He reasoned that an arbitrator need only disclose the facts listed in paragraphs 1 and 2 if they are facts that a reasonable person would consider likely to affect the impartiality of the arbitrator in the proceeding. So, for example, under Judge Epstein's ruling and reasoning, the arbitrator would not have to disclose an existing or past relationship with, say, Mr. GRUNLEY, unless a reasonable person knowing of those facts would consider them likely to affect the arbitrator's partiality. He takes the introductory clause of subparagraph A as, in that sense, qualifying the disclosure requirements of set forth in subparagraphs 1 and 2. Do you agree with that?
No.
And do you think, and why do you not agree with that?
Well, because all it does is apply the old standards. Again, as far as my view of it is concerned, as a counsel, as well as a litigant, as well as an arbitrator, is that once you have failed to make a disclosure, three things must be understood in context. One is the disclosure, and two is the interpretation by the lower court that the arbitrator is the determiner of what might influence his position is a non-starter, because he wouldn't have accepted it if he believed there was bias and that he could be challenged on bias. That it is.
I get that thought, but can I just make sure? So your position is, if I am asked, I'm considering whether to accept a possible appointment as an arbitrator, and I know that I'm 60 and I was in the same kindergarten class with Mr. GRUNLEY. You're saying, and that's it. That's the only thing that I would be able to disclose. You're saying the way you read the provision, I have to disclose that because it's a past relationship. I mean, it depends what you think the word relationship means, but that's a kind of relationship, I guess. We were related in that respect. Is that your view, that no matter how long ago, no matter how innocuous, and no matter how no one would really think that it would give rise to a present effect on impartiality, the arbitrator has to disclose it? Is that your position?
Yes, Your Honor.
And can I ask you, did you make that, or did Allegheny? I know because you were kind of rely on their brief before they bowed out of the appeal. I'm not sure I remember that argument being made by either of you in the briefing in this court. I thought the focus was that the judge was just wrong in applying a pre-RUAA standard, and was wrong in applying the reasonable person test, and was wrong in failing to realize that a presumption arose. But is there a point in your brief or in Allegheny's brief where it's clearly argued that the trial judge was wrong in thinking that the disclosure standard wraps in a reasonable person standard, and instead the disclosure standard is just what A1 and A2 say about any relationship, any interest, no matter how small? Is that something that was briefed by either of you?
It was argued by Calderon in my brief that essentially, if you adopt the lower court's decision, you are then adopting the old standard and depriving the party. All of these provisions are termed in disclosure to the party, that the failure to disclose takes the option away from the party to object to the person. Whether or not that objection is sustained, I am entitled by the terms of the statute to that disclosure, regardless of the arbitrator's determination of whether or not it's de minimis in his opinion. He is not the reasonable person. The party is the reasonable person.
Well, it's not so clear that you are in the position you're taking, which is that the disclosure requirement is any financial person or interest or any existing or past relationship. I don't think it's so clear from the text of the statute. The text of the statute has at the beginning of A, the arbitrator has to disclose known facts that a reasonable person would consider likely to affect, including. And it seems kind of an open and unclear. It's not entirely clear from the wording of the statute whether all of that kind of the known facts, reasonable person likely to affect impartiality is wrapped into 1 and 2, or whether instead it's not. And the trial court addressed that, and kind of wrote a thoughtful analysis, which maybe is right or maybe is wrong, but it explicitly addressed the question and explained reasons why it concluded that the better reading was that the reasonable person standard governs the disclosure obligation. And I continue to be unsure whether there was any argument by you or Allegheny otherwise in this court, but I can go back to the briefs and look at that.
The reason that we disagree inferentially or explicitly is that the caveat to what Your Honor just said is the reasonable person standard. Whether you look in contract law or any other law, it is a reasonable standard is the person standing in the shoes of that person. And the only person standing in the shoes of that reasonable person is the party. If you don't disclose to the party, how can you apply a reasonable standard? If your only application of the reasonable standard is what the arbitrator decides, in his opinion, is a reasonable standard, that is not what the statute says. The statute says a reasonable person, not a reasonable arbitrator. As to disclosure, the reasonable person is the person standing in the shoes of the other party. And without any disclosure, you have deprived the party of his due process rights to participate in the proceeding with a fair and reasonable understanding. I apologize, I lost video. Everybody still there, Your Honor?
We are still here. We hear
Okay.
you and we see you. We'll give you a moment to get yourself adjusted there.
Okay. I'm not as computer literate as I should be, but too old for that. Anyhow, but that is really basic our issue. It's the same thing when you get to the question of damages, and the lower court said that I didn't demonstrate, Calderon did not demonstrate that the arbitrators intended to provide GRUNLEY with a windfall. Well, if that's the burden, to demonstrate the intent of the arbitrator, then what is the evident partiality presumption? The last issue that I know I'm out of time is simply the legal fees, where whether it's section 164421 B or the contract, legal fees can only be awarded after a reasonable demonstration that the fees are reasonable. The court's lower court's conclusion that since GRUNLEY was not awarded all of its legal fees, there's a presumption that they thought something was fair and equitable. Again, there is no evidence. There's no evidence in the record of Mr. Shapiro's involvement other than self-serving declarations. There can be no evidence in the record of the arbitrator's intent or non-intent to award GRUNLEY a windfall. And there's no evidence in the record with respect to the reasonableness of a $700,000 award of legal fees. For that reason, we believe the—
May I ask you a question about that, Mr. Sachs? When you say there is no evidence in the record regarding the reasonableness of the $700,000 award of legal fees, are you saying that no evidence of GRUNLEY's legal fees was presented to the arbitrators? Because, you know, the record of the arbitration, the evidence presented, is typically not something that is going to be re-examined by the trial court on a motion to either affirm or vacate the arbitration award. So I have to assume, I mean, are you saying that GRUNLEY did put in simply no evidence about about the fees it incurred in the arbitration?
I apologize for my misstatement. The invoices for GRUNLEY's legal fees were submitted to the panel without any testimony with respect to the reasonableness of the fees. There were many issues and litigation, and again, I understand the court's limitations or express limitations about reviewing the substance of any evidence, and so therefore I haven't spent any time on the award of damages, but on the legal fees, other than submitting the invoices, there was nothing else. So I hope that I've corrected myself. They did submit invoices.
I'd like to ask you, before you sit down, one other question about the interpretation of section 164423. Excuse me, 4412. and that is subsection E, the subsection that reads, an arbitrator appointed as a neutral arbitrator who does not disclose a known, direct, and material interest in the outcome of the arbitration proceeding, or a known, existing, and substantial relationship with the party, is presumed to act with evident partiality. And I want to focus on those words, known, existing, and substantial relationship with the party. The trial court found or concluded, and he had the affidavit of Mr. GRUNLEY, that Mr. Shapiro's relationship with GRUNLEY was known and it was existing, but was not substantial. And I'd like to hear your argument, your articulation of why it was error for the trial judge to conclude that the relationship was not a substantial one.
Our argument with respect to that is similar to what Your Honor had asked before, is that in essence, the lower court is going to rely on self-serving declarations. And to me, the underlying part of arbitration and the oversight by the court is to enforce due process and fair hearing. It is when something of this significance of the failure to disclose, it's not like there was a disclosure and there was back and forth as to whether or not it was substantive. The after the fact determination without an evidentiary procedure to determine whether or not something is continuing, and the fact there was a 19-year or 20-year relationship is by definition, and maybe that's what this court must do, is to define what substantial is as to the substance of what the underlying issues are between and what resulted in the communication. That is left to guesswork, and I don't believe the lower court had any evidentiary support for its position or its interpretation to state that these were de minimis and would not affect impartiality. That is for the party to raise and argue once there's disclosure.
Well, there was disclosure by the time of the proceeding to vacate or affirm the arbitration award. And you're saying that the disclosure disclosed something substantial in the relationship. Do you have a proposal as to, when you say perhaps this court should define what substantial means, do you have a proposal for what definition we should adopt?
If I was the party, I would want any relationship of a continuing nature to be disclosed, and then I would want to find out the nature and extent of that relationship. And again, I don't want to, I've had so many arbitrations where issues came up and challenges upheld, as Your Honor has asked me, in fact, in one I was involved in where an associate of mine from 30 years ago was selected as the arbitrator. The other side, he gave notice of his prior employment with me. And because he referred to me as his mentor back then, he was stricken. Now, would he and should he have disclosed that he was my associate 25, 30 years ago? Apparently, yes. And so the context of the disclosure is for me to determine as the party whether or not it bothers me to sit in that room with somebody that has been associated with the other party for that length of time. Whether or not you or others as the reviewing court will see that as substantive, that's fine. But one of the things that everybody has left out, which is essentially blaming the non-blaming party, is the first words of 4412A that states, before accepting an appointment. That was not done. Why should Calderon bear that burden when Shapiro accepted an appointment knowing that he had past relationships? And at that point, the inquiry shifts to the party that didn't disclose, to place the party, to place the burden on the party that didn't have the duty to disclose is like asking somebody to prove a negative. And you're asking participants in an arbitration proceeding to go into them saying, I don't trust you. It's, for example, the appellee raised in his brief stating that Calderon could have and should have asked for further disclosures. Why? The letter came back, no conflicts. So what you're saying is that a party to an arbitration proceeding must say to an arbitrator, I don't trust you, give me further disclosures. That, of course, would make him very favorable towards you. I mean, I don't mean to be sarcastic, but that's just,
Take the point.
you know, it just makes no sense. And so I guess in the overall scheme of things, whether or not you agree with me, at some point this course must or should, I don't tell anybody must anymore, including my wife. So you should try to provide the guidance we are requesting, that the burden should be on the arbitrator. The minute he breaches that obligation, the burden then no longer belongs to the non-breaching party. Thank you.
Okay, let us hear from Mr., I may pronounce your name wrong, Mr. Frechtel, and we'll give you a few minutes in rebuttal. Mr. Frechtel?
Good morning, may it please the court. Eric Frechtel on behalf of Appellee and Cross Appellant GRUNLEY Construction Company, Inc., which will refer to simply as GRUNLEY, and Appellee Euro Capital Properties, LLC, which I will refer to simply as ECP. As Mr. Sachs described, this matter arises from an arbitration proceeding, which involved a rather ordinary construction dispute. There was an 8-day hearing. There were several witnesses who testified. There were hundreds of exhibits, and there was extensive post-hearing briefing. The 3-arbitrator panel issued an award in favor of GRUNLEY and against Calderon. Thereafter, GRUNLEY filed a motion to confirm the award, which was met by a motion to vacate the award. The Superior Court considered the arguments and issues in detail, issued a relatively lengthy decision, rejecting Calderon's arguments, and Calderon and Allegheny's subsequently appealed. Calderon is the remaining appellant. GRUNLEY followed with cross appeal relating to a narrow issue. So there are two general topics really that I'd like to touch on this morning. First, Calderon's appeal, which we got into in some detail earlier, and then GRUNLEY's cross appeal. First, Calderon's appeal. I think any discussion of an appeal arising from an arbitration proceeding must begin with just a general discussion about the standard of review. This court has said repeatedly that judicial review of an arbitration decision is extremely limited. and a party seeking to set it aside has a heavy burden. Moreover, the DC arbitration statute expressly limits the grounds for which an arbitration award may be vacated. Calderon raises a couple of issues, and Mr. Sachs discussed them this morning. The first one involves the alleged evident partiality of Mr. Shapiro, one of the three arbitrators, and the arbitrator disclosure requirements under section 16-4412. And the other involves compensatory damages and attorney's fees that were awarded to GRUNLEY by the arbitrators. First, the evident partiality and arbitrator disclosure requirements. During Mr. Sachs's argument this morning, the judges talked about the structure and the language in the relevant statutory provision 16-4412. I think Judge McLeese laid out the provisions accurately in the way that one would analyze an allegation of a non-disclosure and frankly the consequences of such a non-disclosure. Under 16-4412A, there are certain disclosures that shall, and Mr. Sachs emphasized this, the word shall be made by the arbitrator. And Judge Glickman asked questions about whether Judge Epstein below got A correct in the way he read it. He read the reasonable standard into that. That is 1 and 2 under 16-4412A can't be read in isolation. There's a reasonableness aspect to it that's read in. Importantly, though, Judge Epstein said if he read that incorrectly, and analytically you move then, by the way, to 16-4412D, if there is a failure to make a disclosure that's required under A, then under D, upon a timely objection by a party, the court may vacate an award. So there is discretion there. Now, the Judge Epstein below.
Counsel, may I ask you a question about subsection A? It seems to me that if I had been a party to this arbitration, I would like to have known this information. Are you saying that I'm not a reasonable person as defined in subsection A?
Judge Fisher, I would say that it's debatable whether or not the information should have been disclosed by the arbitrator in this particular case. Now, that said, it's important to point out that under D, subsection D, there is discretion that is afforded the judge.
Well, Counsel, you say it's debatable, but I haven't heard you take your side of that debate. So if putting Judge Fisher's question a little bit more concretely, if I'm a party who's suing a general contractor and there's a possible putatively neutral arbitrator who's been suggested, who's considering whether to accept the appointment, who has for decades been on the board of an organization that is intended to advance the interests of general contractors, and has been sitting on that board with the president and other family members who run a general contracting business that is one of the parties to the arbitration. I certainly can see the argument that a reasonable person would think that would be likely to affect impartiality. I'm not quite sure how I see, what's your stab at what you're saying is the other side of a reasonable debate?
Well, Judge McLeese, I don't think that that fact pattern actually fits within subsection A. I don't think that a reasonable person would consider those facts likely to affect the impartiality of the arbitrator in the arbitration proceeding. There's nothing specific or concrete about that type of situation that would give me pause or give me concern. Now, again, somebody might think differently. Now, I would say that
Well, part of the problem is, I guess, the debate you have to, it's not enough, I think, for you to say reasonable people could disagree about whether it would affect impartiality. I think that isn't the standard. If a reasonable person could think, if some reasonable people would think yes, some reasonable people would think no, I would read the statute as requiring disclosure. Do you feel differently?
No, I don't feel differently. I think that's probably.
So then I think your side of the debate has to be no reasonable person could think, well, that is likely to affect, not make someone actually, not actually make someone partial, but affect impartiality, likely to affect impartiality. That seems like a tough side of that debate to me.
Well, so I think that you may be right. And as I said earlier, some of the facts that were raised here, like, for example, the Adam GRUNLEY's position on the board of directors of the AGC of DC at the same time of Mr. Shapiro's membership in the same board. Should that have been disclosed under under 16-4412A? Judge Epstein below said no, and I agree with him. But even if he was wrong, and he said this in his decision, then he moves to subsection D, and he found—
Right, I get that for sure, but your opponent, I think, argues actually he would be wrong to hop only to subsection D. What he should have done, if he'd understood A properly, is he would have kept rolling past D to E, and he would have realized that not only was this required to be disclosed under A, properly understood, but also let's focus, let's say, on the general counsel position and and the fact that GRUNLEY is also on the same, not general counsel, it bore a trade association issue, and that GRUNLEY is represented on the same trade association. That is a known, I think that's undisputed, existing, I think that's undisputed, and substantial relationship. And so I think your opponent's argument, or one of your opponent's arguments, is this was actually a substantial relationship, and therefore the trial court kind of went off the rails in exercising its discretion. What it should have been thinking is, I need to figure out whether a presumption of evident partiality has been rebutted by GRUNLEY. And the trial judge doesn't do that. And if that's a discretionary determination, I'm not sure we can make it for the trial court. So can you tell me, partly, I guess, is substantial is one of the great vague words of law. Sometimes it means more than de minimis, sometimes it means pretty significant, depending on context. Do you think that, what's your gloss, to ask kind of a variant of the question Judge Goodman asked your opponent? If you were going to try to tell us what you think the word substantial means there, what does it add? How stringent a requirement is it? What would you say?
I would say, Your Honor, that it's got to be certainly significant, certainly considerably more than what we have here. And I believe that Judge Epstein actually went through the analysis. He determined that these particular disclosures were neither, were not required to be disclosed under A, nor did they fit the more narrow category under E. Substantial relationship. Here, we've got an individual, Adam GRUNLEY, an employee of the company, who sat on the board with Mr. Shapiro. He remembers meeting Mr. Shapiro only once or twice in person. He does not recall any communications whatsoever with Mr. Shapiro during the relevant time frame.
Yeah, I get all that as far as like the personal connections. I guess what I find a harder challenge for you on whether this was substantial is, and tell me correct me if you think this isn't a fair way of stating the situation. But if the arbitrator who's going to preside over participate in the panel on the panel of an arbitration where I am in a dispute with a general contractor has spent a significant part of his professional career as a leader of an organization that is intended to advance the interests of general contractors. Why isn't that a substantial relationship to one of the parties?
Well, I would say,
Even
Your
if there's
Honor,
not a close, and the particular opponent in my arbitration is also represented on that same board or trade association. Why isn't that substantial? Now, maybe you think that's not what a fair description of what Mr. Shapiro's activities were, but if it is a fair description, on most meanings of the word substantial, I think there's a pretty good argument it was substantial.
well, I think for the same reasons that have been articulated by some of the other courts and some of the cases that we cited in our brief, Your Honor, for one thing, it's certainly not uncommon that an arbitrator in a case, particularly in a construction case, would be involved in a trade organization or even on a board of a trade.
Well, I'm not sure why it matters whether it's common or uncommon. First of all, if you're talking about interest arbitration, sure, it's a whole different can of worms. But if it's common and really nobody's going to care, disclose it and make a determination about whether it's substantial. But I don't know that. And if it's common, all that it does is trigger a presumption of evident partiality. I say all, but that's a significant consequence, but it's not a fatal one, because the party who's defending the arbitral award can come in and say, okay, even if you assume that there was a presumption of evident partiality, we can rebut that. Here's what we'll show. We'll show that, the personal connections were small, and you can look at the whatever else you put in a declaration from the arbitrator. Who knows what you would do to try to rebut the conclusion. But I don't know that there is the structure of the statute permits, doesn't require that there be a very stringent sense of substantiality to necessarily unduly undermine kind of the interest and finality in arbitral awards, because that's not the last step in the analysis. And if there really wasn't a problem, then presumably the party who's defending the arbitral award will establish that. It's just a presumption that's rebuttable. Why should we read substantial as being stringent rather than, it's got to be more than de minimis, but it doesn't have to be more than that?
Well, I think, I don't know, to me, de minimis is one end of the spectrum and substantial is another end of the spectrum. Now, it might not be, it's not complete. And you're right, it only establishes a presumption of evident partiality, which is rebuttable. But substantial to me means it's not just merely more than de minimis. It's got to be exceptional, if you will. I mean, if you look at some of the case law that talks about evident partiality, the Umana case of this court in 2000 talked about what it takes to get to evident partiality. And Judge Epstein below noted that while that case involved the Uniform Arbitration Act, before it was revised, he said it was instructive in terms of what, how to figure out whether there's evident partiality. In that case, the test articulated by this court was, quote, the relationship was so intimate, personally, socially, professionally, or financially, as to cast serious doubt on the arbitrator's impartiality.
Your answer seems to be suggesting that we should roughly equate known, existing, and substantial relationship with relationship that manifests, that actually is evident partiality. And that doesn't make sense. It's got to be, if it triggers a presumption, it can't be the same as the thing. It would make no sense to say in order to trigger a presumption of X, you have to prove X. It's got to be something short of what would by itself amount to evident partiality. You would agree with that, I think.
Judge, I agree with you.
Mr. Frechtel, can I press you a little bit on this with reference to some of what I recollect, I hope correctly, are the facts of this case. do I recall correctly that Mr. Shapiro had actually done legal work for the trade association, the AG, the trade association? He had written, as I recall, a couple of amicus briefs for them in legal proceedings. Is that right?
That's correct, Your Honor.
And so he's been their lawyer, and this is not like ancient history, if I understand correctly. This is something that could be envisioned. A reasonable person might think, well, he writes a couple of amicus briefs, that could continue. And I suppose a reasonable person would think it's likely he or his law firm got paid for that, for doing that work, although he could come back perhaps and say, well, it was all pro bono and a pain in the neck, frankly. But so he's in a position where he has done legal work for the organization in activities that bear some relationship to the subject matter of this arbitration, general contracting and the like. And it turns out that who is the president of the current president of the trade association? Is it Mr. GRUNLEY?
I don't believe, no, I don't believe Mr.
He's
Grunley
not?
is currently the president of the board.
I beg your pardon? He was earlier?
I don't believe that Adam Grunley is president.
So he's not, okay, I misremembered that. But he's on the board, and the other members of the board are also general contractors, representatives. I think a reasonable person could say, you know, being an attorney for somebody and getting repeat business from them. Now that's the relationship with the trade association, not directly with GRUNLEY. I understand that, but that's a pretty substantial relationship, and it may continue. And the people who are going to decide whether it continues are his fellow board members, including Mr. GRUNLEY, one would assume. If you look at the facts that way, why wouldn't a reasonable person say, you know, that should be disclosed? Because what you're telling me is the arbitrator in this case might, in his capacity as a lawyer for this trade association, have the kind of relationship with my adversary in this arbitration that could cause me some concern. How do you respond to what, now maybe I got the facts wrong, but if I haven't, how do you respond to that rather concrete suggestion that there's something that a reasonable person might find substantial here, and certainly the kind of thing that a reasonable person would consider likely to affect the arbitrator's impartiality?
Judge Glickman, let me start first by just gently challenging the facts.
Please do. I said I may have gotten them wrong.
And it's in this way, really. So the trade association that we're talking about, I think there's a little bit of a misnomer. It's called the Associated General Contractors, but it's really a trade industry for it's a trade organization for the construction industry at large. And I think we pointed out in our brief that it may well be that Mr. Sachs's client is a member of AGC. I don't know that. I'm certainly not representing that they are. I haven't found evidence of that, but it could well be, because they are a trade industry for or trade organization for the entire industry. Now,
I just want to make sure, what's your basis for saying that exactly? I mean, the name suggests that they're focused on a particular component of an industry where subparts of the industry are sometimes at odds. And so what's the factual predicate for your assertion that although, I don't know. I mean, is there any evidence that there was any member of the board or of the group that is not a general contractor, or a lawyer who represents general contractors, or someone else affiliated with general contractors?
I don't know the answer to that question, that specific question, Judge McLeese. The reason I said what I said is our review of principally our review of the website, which indicates what I described, as I recall. And also my association with or my knowledge of the trade group. I believe that's the case. In fact, so I now have, or I did have,
Yeah, I mean, one wonders how much weight you give that, the former, not the latter. I mean, you know, probably there are a lot of interest groups that say, you know, that are all of their members are, you know, are part of a particular industry. But if you looked at their website, they'd say, well, we're looking out for the interests of all Americans, or, you know, we're pursuing the public good. And so, you know, I'm not entirely sure how much weight to give what's said in the website as against whatever concrete information we have about the name and the activities that we, as far as we know, such activities as anybody's identified have all been focused on representing or advancing the interests of general contractors rather than some sort of pro bono. Even we'll try to lift the boat even of our adversaries.
That could well be, but you know, the website says what it says, and again, it could well be that Calderon is actually a member of the organization. In any event, I think that it would certainly be different if, let's say, Mr. Shapiro actually represented GRUNLEY in a case or previously, and there's no evidence that Mr. Shapiro ever represented GRUNLEY. You know, I noticed, I think it's important to point out, the language in subsection E is a known, existing, and substantial relationship with a party, okay? And for one thing, that's different from the language in A, which extends beyond party to their counsel, representatives, a witness, or the other arbitrators. So that goes to a point that was made earlier, I think, by you, Judge McLeese. In any event, that would be if there were that kind of relationship where Mr. Shapiro not just merely represented the AGC in two amicus briefs, for which he may not have even been paid. We don't know one way or the other. But those are two in the record. There are two very limited engagements, amicus briefs. It's not like there's evidence that he was, for example, general counsel for the association. Nor is there any evidence that he, as I said, represented GRUNLEY. I mean, this organization has thousands of members, and you know, for Mr. Shapiro to have submitted two amicus briefs, I don't know how you get from there to there is a substantial relationship with GRUNLEY.
Can I ask you a question? Assume for a moment, arguendo, that this court were to conclude otherwise and were to say, really, the only correct answer, maybe even if we're deferring to the trial court, if we said, look, you know, the only correct answer here, the only permissible answer is this was a known, existing, and substantial relationship. So a presumption of evident partiality, if the trial court had been doing this correctly, the trial court would have realized a presumption of evident partiality was triggered. If we reached that conclusion, could we still rule for your client, or would we be required to, you know, at least send the matter back for the trial court to figure out whether such a presumption was rebutted?
I would say the latter. You would send the case back to the court, remand it back for further proceedings relating to whether the presumption is rebutted. Now, I would say, though, that I think an important piece of the puzzle here in response to your question, Judge McLeese, is there's deference that should be afforded the court below in connection with these findings. I mean, at minimum, these are mixed questions of law and fact. We've got application of fact to law, and at a minimum, the factual findings receive deference and are subject to the clearly erroneous standard. Now, when you apply the facts to the law, arguably that consideration is de novo, although it's not entirely clear. I mean, if you look at the Narayan court, the case that we cited from a recent case out of Hawaii, they actually, they took a different view on the standard of review in this sort of situation. Here, of course, we would look at the recent case of Jewell versus Rawlings. Judge Fisher was on the panel, and it appears, and that cited actually Judge Glickman's decision, Federal Marketing Company. And it appears that it would be, this is a mixed, a situation of mixed fact law, and the standard would be probably de novo on the law side.
Counsel,
yes, sir.
let me ask you about a factual question I presented to Mr. Sachs at the outset about the resume of Mr. Shapiro that appears in the appendix. Do you know whether or not it was disclosed before he served as an arbitrator?
Judge Glickman, I do not know. I'm sorry, Judge Fisher, I do not know is my answer. I'd have to look back. I don't know offhand.
Thank you.
And I would say that it was at minimum, it was available. I mean, it was on his website or his firm's website, so it was available to the parties, but I can't say that it was actually transmitted by me, for example, as counsel for GRUNLEY and ECP, or by Mr. Shapiro.
So the
I have
appendix
some
doesn't
questions.
indicate- I'm
Go
sorry.
ahead, Judge Glickman.
Well, I was just to be sure that the appendix doesn't indicate when that resume or the circumstances under which that resume was produced.
Not
Is
that
it-
I can detect.
No. Okay.
I would like to ask some questions about the amount of compensatory damages, if my colleagues are ready to turn to that question.
Sure.
Can you help me understand, should this settlement that was reached between GRUNLEY and Euro impact the amount of the award in this case?
No, Your Honor. There's no nexus between the settlement agreement between GRUNLEY and Euro Capital and this dispute. So there's just no nexus between the two.
I'm not sure I understand the no nexus point. I thought that this settlement agreement related to the renovation of the Watergate.
It did. The settlement agreement between Calderon and Euro Capital effectively, GRUNLEY and Euro Capital, I apologize, effectively closed out the project and resolved issues between GRUNLEY and Euro Capital. And as part of the settlement agreement, GRUNLEY agreed to defend Euro Capital in connection with any claims brought by Calderon. So it's relevant in that context. So really effectively, Euro Capital in the dispute with Calderon had no risk. It was really not a party that had any real interest.
I understand Mr. Sachs to say, well, look, Euro and Calderon settled all their differences. That means Calderon or GRUNLEY has been made whole. How dare they try to get more damages out of Calderon?
Judge Fisher, there was no agreement between Euro and Calderon. If that's what you meant to say.
I misspoke.
Okay, I just wanted to be clear about that.
Why wasn't GRUNLEY made whole by that settlement agreement? And how dare they seek additional damages from Mr. Sachs's client?
That's just not what is in the record, Your Honor. GRUNLEY was certainly not made whole by Euro Capital. In fact, there was testimony and documentary evidence that was submitted to the arbitrators reflecting that GRUNLEY lost $10 or $11 million on this particular project, and that if Calderon had not defaulted, then if Calderon had not defaulted, then GRUNLEY's loss in the case would have been something in the neighborhood of 7 or 8 million. And this was explained using job cost reports and related documents to the arbitrators.
What specific losses of GRUNLEY were the payments from Euro Capital meant to redress? What was Euro Capital paying GRUNLEY, whatever it was, $4 million, I think, something like that. What was Euro Capital paying GRUNLEY $4 million for?
There were numerous changes and disputes on the project that were at issue and in dispute between, as I said, disputes between GRUNLEY and Euro Capital that had nothing to do with Calderon. I mean, this was a large project with numerous subcontractors.
In other words, those disputes did not have to do, what I understand you to be saying, but you haven't actually said it explicitly. So let's be, those disputes for which Euro Capital paid GRUNLEY $4 million had nothing to do with alleged failures of Calderon and costs that Calderon caused GRUNLEY. Is that what you were saying?
I mean, Your Honor, I don't know that I can say that, especially not today. But I can say that GRUNLEY put on evidence at the arbitration of its own damages in connection with the Calderon default on the project.
If you can't say nothing to do, can you say accurately, in your view, or would you be confident saying that at a minimum, it included other things beyond any damages that were caused by Calderon, so that it wasn't limited to the dispute? It wasn't like entirely focused on damages that arose out of the problems with Calderon.
Yes, unequivocally.
Let me confess that I have not yet understood how the arbitration panel came up with this damages award. Is your response simply that I don't have to understand it? That illustrates the limited review we conduct with respect to arbitration awards?
I don't know that I want to be arguably that rude. But I will say that I can walk you through the documentation or the explanation. I mean, I think the damages presentation to the arbitrators was very straightforward, and it was consistent with the terms of the subcontract that dictate what damages are recoverable in the event of a subcontractor default. There was nothing out of the ordinary about the calculation. It involved the costs that were incurred in connection with the default, minus the subcontract balance that had not been paid to Calderon, and then effectively the difference, plus the attorney's fees that were incurred in connection with the dispute. So that was presented. The panel issued an award that was actually something less than GRUNLEY was requesting. And as they are entitled to do, and actually as agreed upon by the parties, importantly, there was no explanation. There's no reasoned decision. It was just an award with a number on a form that was prepared and submitted to the panel jointly by counsel for all the parties. So that's kind of, I guess, hopefully that responds to your question, Judge Fisher, but that in a nutshell, I think, is kind of a description of the damage award.
What I take away from your briefs and what you said today is that, except for the question of failure to disclose, there is no basis for setting aside the arbitrator's award. Is that fair?
Well, there's no basis to set aside the award at all, because.
Agreed, but
okay.
If we get past the disclosure debate,
right,
you seem to be saying if we focus on the, forgive me, merits of the award, there's no basis for setting it aside.
That's correct, Your Honor.
Can I ask you a quick question about, we haven't talked about your cross appeal, you've been up a long time, but a quick question about your cross appeal. I mean, I understand your position, which is if you look at the wording of Rule 54D, it seems to contemplate that you can file kind of a bare bones initial filing, and then if people want to fight about it, there can be supplementation and further documentation of a fee award. And then the trial court kind of jumped the gun by saying, well, that's inadequate, the end. In support of that view, I mean, you tie your argument to the language of Rule 54, but in terms of other authority that has supported that way of looking at it, you cite Wright and Miller, which some people think is better than a case cite, and it does. I think Wright and Miller does support the position that you're taking. But I mean, there are at least two other things that maybe point on the other side. One of which is, I mean, ordinarily with a motion, if you ask the trial court to do something, you need to include the allegations and information, at least, alleging the circumstances that would support the judge granting your motion. And we do have cases, not zeroed in on 54D, that say that fee applications need to be sufficiently detailed and the like. And so I'm wondering, I guess, how extensive was your research if you can't find any court in the country that has adopted this view? And I don't know how many states have rules that are like 54D in their wording. Obviously, the federal system, though, the federal rule is virtually identical. So it gives me a little bit of pause that you don't seem to have found any court that's agreed with you.
Your Honor, I am not going to represent to Your Honors that we had conducted exhaustive research in connection with this issue. And I guess as part of my answer, so I can't say whether there is more support for our position out there than we identified in our brief. I agree with you that the passage in Wright and Miller supports our position. And we read the rule, we followed the rule. We never anticipated that there would be that our motion would be summarily rejected. Could we have submitted all of our bills without redactions? In hindsight, yes. Unfortunately, hindsight is hindsight. We did it the way we did it. I feel like we complied with the rule, and I feel like it was error for the court below to deny the motion as it did.
What stopped you from going back to the court and in one way or another seeking reconsideration and offering to supply the additional material?
Judge Glickman, that's a good question, and I think I've thought about that too. I recall the reason is we were anxious to be done with this, and we were anxious to get paid on the principal amount of the judgment, which did include attorney's fees that were incurred in connection with the dispute below, or not below, I guess, during the arbitration. Relatively speaking, the amount of attorney's fees and expenses that were incurred in the contested judicial proceeding relating to, post-award and relating to the award, relatively speaking, it was not a huge amount of money. We were anxious to be done with this, to get our client paid on the judgment.
Ask you, if you were to prevail in this appeal, would the natural order of things be that there would be a fee request relating to the fees in connection with the litigation of this appeal?
Yes, sir.
That's what I thought. Thank you.
One other question relating to this, if I may. I just don't remember. When you filed your fee request for the work to confirm the arbitration award, did Calderon oppose the fee request, arguing that the documentation was too that the requisite documentation was missing?
Judge Glickman, I do not recall an opposition filed, but I can't say with certainty. I haven't looked back at that.
Okay.
I'm sorry.
That's all right. I'll ask Mr. Sachs when he returns to the podium.
Unless your honors have any further questions, I would say that I'd reserve the balance of my time, but I don't think I have any. I would respectfully request that the court deny Calderon's appeal and remand the case back for further proceedings on GRUNLEY's motion for attorney's fees and expenses. Thank you very much.
Thank you. Mr. Sachs, let us give you a few minutes, and perhaps you could begin by answering the question I just asked about what, if any, opposition there was to the fee request.
Would have to look back, Your Honor. I think we did file one, but it may have been that the judge denied it before an opposition was filed. And what I had found interesting was going to raise to the court that essentially Judge Epstein really pretty much recited the cases that we used to defend against GRUNLEY's assessment of the $700,000 awarded by the arbitrators, was that there was nothing demonstrating the reasonableness of the fees. But as to whether or not we had time and in fact filed one, I don't recall whether we got the order first denying it. There were a lot of motions at the end that I can't recall right now. I apologize. The only point that I was going to bring up is that it was interesting to listen to the exchanges. And one of the things that came to me is that going back, that both between counsel and the court was this argument over specific or concrete information with respect to the determination of whether something is substantial. I think it is critical, and I think I made the point, if not, I will make it here, is that without the disclosure that would have allowed further inquiry, this is what I was referring to about the lack of evidence. If a party, in this case, the arbitrator, fails to disclose information, thereby preventing inquiry into whether or not the proceeding is substantive, whether the relationships are substantive, then is essentially denying the party the right to that information, and to reward that by saying, okay, now after the hearing, we found this information. Now let's determine whether it's substantive. I think it's the cart before the horse. If the arbitrator fails to disclose. I'm sorry, you're muted, Your Honor.
Sorry about that. I may have misunderstood something you just said. I did not have the impression that Calderon was denied the ability to inquire at the very beginning when Mr. Shapiro's name came up as to his relationships or anything else. I understand he had an obligation himself to come forward with relevant information, but nothing stopped, am I correct? Nothing stopped Calderon from inquiring of its adversary, say, who is this guy and what's his background? Am I correct about that?
I totally agree, Your Honor. It came back, it's what I go back to before, with an affirmative statement of no conflicts. The question then is asking why I would inquire further. I think that's requesting me to speculate, and again saying that that's very nice, you made no conflicts, but I don't trust you.
It's just this question saying, I'd like to know about this person. What's his background? Let me have his curriculum vitae.
Well, the issue of the background came up I'm sorry.
Did Calderon, there's been this issue of the resume of Mr. Shapiro contained in the appendix. Did Calderon have that resume at any prior to the arbitration?
No, Your Honor. That I
Do you know
don't.
where it came, and you don't know where it came from or how it got in the?
No, it wasn't supplied. Correct.
It wasn't an attachment to an email because it's in there with emails.
It was nothing I have in my email search.
Okay.
And that's really, I appreciate the court's time. And I'm there. If there's any other questions, I'd be glad to.
Counsel, thank you both very much. The case is now submitted, and we can excuse you, and you may log off, and we will turn to the next case.
Thank you very much.
We'll call the case of In Re JW. Counsel, you may proceed.
I'm sorry, Your Honor. Oh, I was waiting for appellee. I apologize. Good morning. May it please the court, Claire Pavlovic on behalf of appellant JW. I'd like to begin my argument today by addressing the excited utterance issue and then turn my focus to the precluded confrontation about the criminal ties among Kevon Chandler, the Jones twins, and Joseph Morris. I'd like to reserve 2 minutes of my time for rebuttal. The statements made by the Jones twins were not admissible under the excited utterance exception because the twins' desire not to speak to the police exhibited reasoned reflection about what was most in their own self-interest. That reflection and the steps the twins took as a result showed that they were not under the immediate and uncontrolled domination of the senses and rendered their subsequent statements not spontaneous and inadmissible.
Can I ask you a threshold question about standard review? Because the parties do seem to dispute that. And I can understand why the parties dispute it, because it seems to me our court has said a variety of ambiguous, arguably inconsistent things on the topic, and about hearsay generally, but about excited utterances in particular. But I do think we tried to bring some order to the things we previously said in the Mahan decision, which your opponent relies upon. And I take your reply brief to argue that on a correct understanding of Mahan, if a trial judge doesn't make any mistakes of law, doesn't make any clear errors of historical fact, and then kind of says, okay, these are the circumstances, these are the kind of relevant considerations, now I need to make an ultimate judgment, admissible or not admissible. Your opponent argues that ultimate judgment is reviewed deferentially by this court and relies on Mahan for that conclusion. I take you to argue that that's not right, and that you view us as being performing the function of kind of de novo deciding that question. Am I right in understanding your position?
Yes, I think this court has said many times, and indeed just a few weeks ago, said again that the question of whether or not, in the context of an excited utterance, that the question of whether or not a statement qualifies for a particular hearsay exception is a question of law. And I think that
in defense of Mahan, that's less about how to read Mahan and more about other things we've said. And in defense of Mahan, you can also find cases that say we review that determination for clear error. You can find, if you go on a hunt to find formulations, you can find a lot of them that it's hard to reconcile.
Right. Well, I think it's not that hard to reconcile, because I don't know of any case where the court has said that a statement doesn't meet the exception, and yet the trial court didn't abuse its discretion. Or
of course we have.
That's not the clearest answer.
Yeah.
I think if you look at what the court is doing in Mayhand, it is doing a very searching review and saying, do these facts permit the trial court to make this determination? And I think you can either characterize that as hearsay exceptions are a pure legal standard, and that's a question, and whether or not a statement meets that standard is a question of law. Or you could view it as saying, under sort of Johnson's historic formulation of the abuse of discretion standard, you could sort of view it as there is but one way to exercise the discretion in this case.
Can I ask you, I don't mean to derail the standard review, delay us too long on this, but I wonder if there's a tension between the position you're taking about excited utterances and the position you take about prior statements of identification, where, there's a complicated issue about whether whether some of these excited utterances or alleged excited utterances would be admissible under that rationale, and relying on a case of ours called Randolph. The chain of reasoning that you take is, well, that's a discretionary determination, the admissibility under that hearsay exception, and appellate courts don't have discretion. And so to the extent you're saying it's kind of well settled hearsay, whether something fits in a hearsay exception is a question of law, that seems contrary to what we said in Randolph about that hearsay exception, and contrary to the whole kind of premise and reasoning of Randolph and the way you rely on it. So is there a way, do you think the standards are different and it's de novo for excited utterance and it's deferential for prior statements of identification, or can you help me?
No, and I,
way through that?
I understand that question, that tension. I think that the court has always said that the ultimate decision about whether or not to admit a particular statement is always going to involve some amount of discretion. And there's going to be some amount of discretion in the fact finding that the court does in order to determine whether or not the foundation has been laid based on the particular testimony and the credibility determinations and things of that nature, and the arguments that are made to the judge and things of that nature that go on at trial. I see the point, and I think that it is a complicated, and frankly, I also find it a somewhat confusing area of this court's case law, but I wouldn't want to, I don't think in the end it's that significant, because I think that if you look at the review that's being done in Mayhand and Peltzer and Graber-Mannen on our more recent cases, it's a very searching review. And I think that if that is how the court reviews excited utterance determinations, then it doesn't really matter whether you view it as an abuse of discretion or whether you review it as a de novo question. I think that the review that the court does in those cases shows that in this case, the trial court had no discretion to admit this statement as an excited utterance.
But there's a key question, isn't there? If a judge says, I've listened to the testimony, I credit what the witness says, and I decide that she was still so excited that she was not reflecting or calculating before she gave an answer. Do you agree that that's a factual finding?
I think that it could be a factual finding, but under this court's case law is legally insufficient to meet the test. I think that in this case, we actually have no testimony at all about what the twins' demeanor was in the intervening time period before they arrived at their aunt's house. And in fact, Megan testifies, and she doesn't testify that she was crying, that she was upset, that she was hysterical. She doesn't testify that she was so confused she didn't know what she was doing or what she was saying. And I think under those circumstances, we're in a very similar situation to what the court recognized in Peltzer was sort of a collapsing of the first two steps of the test, right? Peltzer said you can't, if you try to infer from the subsequent state that there was that the initial state existed, you're sort of collapsing the first two pieces of the test together. And here, you know, we have a situation where the facts strongly suggest that what in fact was going on was much more akin to reasoned reflection than to a suspended state. You know, this exception, the entire premise of the excited utterance exception is this idea that there is a mental state that can produce essentially a verbal photograph of the contents of the mind, right? Which is what Odom's discusses a lot. It's the idea that these statements are essentially a physical reflex, and so they can't be distorted because there's no sort of conscious thought that goes into them. And what Odom's also says is if you're not in that totally reflexive state, then the entire justification for the premise disappears. And
why can't you have different states with respect to different stimuli? For instance, if you have the sense to get out of the way of a speeding car to save yourself, and then blurt out that you just saw somebody shot, does the fact that you had the sense to get out of the way of the car mean that you did not give an excited utterance when you told about the murder?
Well, I think that I think that the facts of this case are very different than that hypothetical. I think, but I do think, you know, it's debatable whether or not that exhibits reasoned reflection, but it kind of depends on what the testimony is in that case. If the testimony is, you know, well, I saw a car and I just reflexively jumped out of the way, and then I was like so distressed, and so I said, oh my gosh, so-and-so shot so-and-so. Then maybe you're in a position where you can say that that person was still in a reflexive state. But here we have the declarants engaging in all kinds of behavior that suggests that they are not in that state.
Can I ask you that you're putting a lot of weight on this idea of reflexive state? It's sort of, there was no higher cerebral function going on. It's like someone, you know, hit them in the knee and their leg went flying as a physical reflex. And if that's an absolute prerequisite, then a lot of our cases seem incorrect. And our cases spread out over a variety of circumstances. But I mean, if someone asks me a question and I answer it by using well-formulated English that is responsive to their question, I don't think anybody can think of that as like a physical reflex. I mean, you can't do that by reflex. Now, maybe you can scream or something, but you would think that if the test really is, unless the circumstances permit a conclusion that there was no higher function and it was just thoughtless reflex, what came out of the declarant's mouth. Any case where it was an irresponsible question should come out as inadmissible, which is not what our law is. And so I'm wondering whether the idea that it's an absolute prerequisite that it be understood as a physical reflex can be squared with the outcome of many of our cases.
Well, I think that regardless of whether you think it's an absolute prerequisite that it be, I mean, I think that Odom's does say it's not just rote recitations of people being excited that gets you this exception. It is in fact this sort of searching, and Peltzer uses the phrase fact-based review. And so I think that regardless of what the sort of de minimis amount of reflection that's needed is, whatever that de minimis amount is, we've surpassed it here, where the testimony is that, you know, there's this whole period in which Megan testifies she's, you know, she sees that James has been shot. She goes to him, she's talking to him, she's telling him not to move, she's telling him to stay awake. And then her uncle says, you know, go because the police are coming. And so she decides to stop what she's doing, to stop comforting her friend, to stop doing, all of that, and instead, walk away because the police are coming. And I think that if you are in a position where you are comforting somebody, if you're in the position where you are making sort of collective decisions about where and how to go different places, then whatever the de minimis amount of reflection is, you've really surpassed it.
Can I
certainly get your argument on that. Go ahead, Steve.
Well, I think I'd like to press you on that. The question is whether the declarant has reflected on the statement that's at issue, whether or premeditated or constructed it. I'm quoting from one of the cases, the standard formulation test. And then the second question is whether the circumstances in their totality suggest spontaneity and sincerity. I'm having a little trouble seeing how the behavior she did suggests that, it would be different if the statement at issue were a detailed recitation of the events that occurred. Here's what happened first, here's what happened second, so on and so forth. But that's not the kind of statement we're talking about. We're talking about a simple statement that JW did it. And this is a statement that's made very soon, realistically speaking, after this terribly shocking event. Her friend is killed in front of her eyes. And the fact that she's done a few other things, such as walked around and tried to get and tried to comfort the dying JW and so forth. I don't know that suggests to me that she has reflected or premeditated or constructed her statement that JW did it. And the fact that she is, according to the aunt, hysterical and crying and deeply moved when she makes that statement to her would seem to support the judge's finding that the statement is sincere and spontaneous. How do you respond to that? I'm just having trouble seeing why we should say this is a constructed, premeditated statement, reflected upon statement.
I have a couple of responses to that.
It could have been, for example, a statement that it could have been, for example, offered as a statement of present sense impression.
It absolutely could not have been offered as a statement of present sense impression.
10 minutes is too long, maybe.
Far too long. It absolutely could not have come in under that exception at all. And I think that is,
well, they didn't try.
Important. I have several responses, but I think that the important place to start this inquiry is this is inadmissible hearsay, which is presumptively unreliable unless it meets an exception, right? And the point of the exception is to say the reason we find these things reliable instead of unreliable, it's not about a specific length of time. There's no safe harbor. There's no just rote recitation of being upset. It's not things that you say when you're upset. That's not the exception. The exception is, and this court has said again and again and again, is the complete and uncontrolled domination of the senses. And here, the government's witness testified.
Again on the standard. Here too, we've said a lot of things. One formulation that seems less stringent is the one that Judge Lichtman referred to about whether the circumstances considered in toto suggest spontaneity. That sounds a lot less stringent than complete and utter domination of the senses. So our cases in what we've said aren't necessarily all. Not all of our sentences seem congruent, and so I do want to. Rather than what we've said in our cases, which does seem to give here too a kind of a smorgasbord of linguistic formulations one could pick. Could you situate this case in the factual circumstances and outcomes of our case? And what I mean by that is, do you think that if there's a case that or two, or that you would say, if you go read that case and you consider the totality of the circumstances here, and you compare the totality of the circumstances in that case, you will see that, consistent application of what we've said would require a reversal here rather than affirmance. So what case would you say, go read that case and it's, our case is sort of off shore of that. You reverse there, you've got to reverse here.
Well, I mean, I think probably the best cases, the most factually analogous are probably Peltzer and Gabor-Maden, both situations where—
Gabor-Maden, which I'm quite familiar with, had a difference that was a substantial point of emphasis in the opinion in Gabor-Maden, which was the statement that was being introduced, that was admitted as an excited utterance was, I forget, but like several hundred words long. It was like a long narrative of what went on. And there was a lot of emphasis given in Gabor-Maden to that circumstance.
Well, that is a fair point. That is a fair point. I suppose what I think is important about it is that it does make the strong point that you can be upset and not be under the uncontrolled domination of the senses. But I think, if you're looking to the most analogous circumstance that we think is really important, I think both Peltzer and Mahan include a discussion that I think is very, very relevant. And that's the discussion about the difference between, say, a person who calls 911 and a person seeking assistance and a person who calls in order to document, right? And the reason I think that's really important is because here, the decision that the twins make to walk away because the police are coming, if you know that the police are on their way and you decide that you don't want to talk to them, what you're doing in your head at some level is saying, what I say about this incident has ramifications for me. It necessarily replies a kind of reflective distance from what you saw, and it raises the possibility not just of fabrication, but of distortion. And in not wanting to talk to the police, it shows a concern about the future. And if you're thinking about who you're going to tell something or not tell something, you can just as easily be thinking about what you're going to tell.
Why would she distort to her aunt? Why would she lie to her aunt about who she saw shot? Or maybe you think that's the wrong question. It doesn't matter.
I think that's absolutely the wrong question. I think that that's not a question underneath this exception at all. I think that the premise of the exception is
Well, it is because the question is whether the remark is sincere.
No, the question is whether the remark is spontaneous.
Spontaneity and sincerity of the remark. I was quoting from some case.
And I would think that it's at least potential. I'm not sure whether I think it is a relevant question or not, but it doesn't seem to be obviously irrelevant consideration. If you're trying to figure out whether a comment is spontaneous and it is made to someone who where there wouldn't be an obvious reason to be calculating and calibrating your answer, that seems to me to be more consistent with spontaneity, arguably at least, than if you were making it to someone and you were sort of, it's someone as to whom you might well be very careful about what you said. So if you don't have a reason not to be spontaneous, then maybe that would tend to be a circumstance that would be relevant to whether a particular statement was or wasn't spontaneous. But I agree. To me, it seems it might have some relevance, but I'm not sure it would have large relevance. But I'm a little unsure it's actually zero relevance. But
well, I take your Honor's point that maybe it doesn't have a zero relevance, but I think it's also, another thing that I think is really important not to lose sight of is that this is the government's burden to show that they have met the rigors of this test, because the statement is presumptively unreliable. And here, there is no testimony about what happens in this at least 5 to 10 minute period where they're engaging in these evasive maneuvers, and there's no evidence of their demeanors, there's no evidence of their mental state, and it's their witness who calls, who they call and testify, and they don't ask her, and they don't put that information in the record, and now they want to urge that you can infer back from their excitement when they come in to talk to their aunt about what their mental state was during that entire time. And I just think that that's a completely unfair inference on this record, because I mean, maybe they're excited because they're in a group of friends, they're a group of teenagers. Maybe they're working themselves up as they're on this walk, right?
I said I didn't want to derail us too long with standard review, but backsliding a little on that. It does seem that the comments you're making now about there being a burden on the proponent of the evidence, and that there are some facts we don't know that are relevant to kind of the trial judge's determination about the mental state of the declarants at the time of the alleged excited utterance, makes it seem a lot less purely legal and more, that approach to it makes it sound almost purely factual. But it certainly doesn't make it sound legal. I mean, if the judge is just making a legal determination, the ideas of burdens and facts and all seem off topic.
No, I think it's a question of is there sufficient evidence in the record for the trial judge to rest his determination on. But I don't want to let this point go unmade. If the standard is the abuse of discretion and the judge does absolutely nothing and never addresses the fact that there's this gap in which the twins are engaging in all kinds of actions, I mean, I think that is classic abuse of discretion, right? And so I don't know that the government gets very far by arguing that you should be reviewing it for abuse of discretion versus de novo. I think that there are reasons to say, and I think I've tried to articulate.
Could I ask you a follow-on question about this? This is not an argument the government has made, but it's a question that has occurred to me, and I don't think I know the answer. So maybe you do. Let's assume that the statement should have been excluded as that the statement should have been treated as hearsay, and therefore not admissible for the truth of the matter asserted. One reason the statement is important, maybe the most important reason, perhaps, is its bearing on whether any error of a Sixth Amendment nature was harmless beyond a reasonable doubt. And the government's argument is we can say it's harmless beyond a reasonable doubt because the twins were identifying JW even before the source of the alleged bias that's an issue arose. Can one say, look, even if those statements were inadmissible hearsay, they can still be admitted, or they still have relevance or probative value for the very fact that before the robberies, before the twins were implicated in the robberies, that source of bias arose, they were saying that JW was the robber. And so whether or not what they were saying comes into the truth of the matter asserted, it comes in to show that the allegedly biasing robberies had no real effect here, were harmless. Now, I understand there's a separate argument as to whether they're harmless or not, but I'm just wondering about the residual evidentiary value that can be attached to the statements to the aunt, even if they are not statements admitted for the truth of the matter asserted. Do you have a view on that? As I say, the government has not argued this, and I have been sort of wondering it, and I'm not sure what I think.
Well, I mean, I would say.
And I
as
know,
an
and I
initial
know your
matter-
first answer is going to be that since the government didn't argue it, we should not consider it.
Correct.
Okay.
But were
So
you
now-
to not be persuaded by that? I mean, I think what you're articulating is a sort of prior consistent statement to rebut motive to fabricate. I think that if that was the context in which they were being admitted, they wouldn't, it's very, the government didn't argue that below. And so for all the reasons, you know, we think that you can't affirm on an alternative.
Well, it's funny because,
reply to that, but I think
usually
also,
when we consider harmlessness, by definition, the government didn't argue it below, but more important, they didn't argue it here, you could say, but.
right, but I think, you know, a statement of, to rebut motive fabrication, it's a convoluted, exceptional phrase. To rebut a motive to fabricate, a prior consistent statement to rebut a motive to fabricate. The other party has to put the motive to fabricate on first, and then, you know, and then you can maybe offer it in rebuttal. That is emphatically not what happened here. And I think it is important because I think the timing, all of the timing and all of those things matter, and what comes out when matters. But also, I really want to make the point that I don't think that the timing is at all problematic for our bias theory. And I don't think that the timing actually creates a problem. And so I don't think that even on I think on an error point, they didn't argue it. It didn't come in that way. It didn't procedurally come in the way it would have needed to come in that way. And it certainly wouldn't have been able to come in as to Melissa that way because the government didn't call her. But I think that in any event, it's.
Well, that's a side issue. I don't want to go down the byways of all this thing. Go ahead.
Could you say concretely, though, why you think you may be about to do this, but you said you don't think timing is an issue. It really wouldn't affect the magnitude of the bias, and therefore doesn't help the district on harmlessness. Can you walk us through that?
Yes, I think there are the first reason is that the bias that we were most precluded from eliciting were the criminal relationships between Kavan and Morris, and then Kavan and the twins. The relationship, that relationship was what was biasing, and the fact that they were in these criminal conspiracies with one another is what was biasing. The particular instances that we had evidence of were just sort of illustrative of that. They were discrete events probative of that bias, but our theory was never that that those biases arose at the time that the robberies were committed or anything of that nature. But then further,
can I just ask you about the criminal relationship theory? I mean, these are, leave aside for a minute, Kavan, who is, I guess, a little differently situated maybe, but focusing on the twins for a moment. I mean, the issue is, the theory is they have a bias to try to help their father, who's, you know, concocting this scheme to get rewards and to get benefits for his, and to get him out of his situation, his criminal situation. I mean, couldn't a trial judge reasonably say, there's a prejudice probative balancing. These are his daughters, and there is kind of all of this other information on that topic about they want to help their father. And if the issue is, and we want to also prove that their father, that, you know, that they act in a criminal way, they act in criminal concert. I would have thought that a trial judge might have discretion to say, that's not going to add a lot and it would be prejudicial. So you disagree? You think the judge
I
would be...
disagree. I think that there's absolutely no grounds for, and I think that this is what Rocky Brown stands for, that there's no grounds because something may be prejudicial to a witness or embarrassing for a witness that an otherwise distinct distinct relevant bias.
I'm sorry. So your legal, are you saying that a judge can't say a party would like to introduce some information that isn't logically relevant in assessing the credibility of a witness, but could well be misused by the jury so that the jury won't fairly assess the credibility of the witness? And you're saying that's not that couldn't be a grounds for a judge balancing prejudice probative and saying it doesn't add much and it will kind of smear the witness in a way that will interfere with the jury's accurate resolution of the matter. You're saying that there's no room for prejudice as to a witness?
No. That's not what I apologize. That's not what I was saying. I think that where you have a prototypical type of bias, which criminal ties are, like gang affiliation, being drug dealing partners are a very recognized prototypical form of bias. And in a situation where the government's only witnesses, or all three of them, are actually criminal co-conspirators, that bias is extremely relevant. And once it's relevant and it's distinct and there's nothing else that's come in on it, then the defense has to be able to explore it, right? I think that right, because that's what the Sixth Amendment case law says, is that the trial court's discretion to exclude cross-examination only kicks in once sufficient confrontation to satisfy the Sixth Amendment has been come in. And the court.
Well, but I mean, if we're shifting over to the Sixth Amendment discussion, I guess a little bit here. If the one way of looking at this, arguably, on this exact topic, is that if the defense wanted to cross the twins, at least on the theory that they have a motive to fabricate in this case because they have an interest in helping out their father, and an interest in trying to help get money through rewards and the like. And there's cross on all of that to a degree. There's a question about whether there was adequate cross on it, but there's some cross about those theories. The defendant wants to cross them to show as an aspect of that bias in favor of the father, or I'm not quite sure bias, motive to skew testimony, at least. I'm not quite sure who it's biased relative to. But motive, at least, to not tell the truth, wants to say, well, and by the way, in addition to the filial affection that you would assume, and in addition to the evidence that there is about this conspiracy and their interest in trying to help their father and his interest in trying to get them to do so, they also just generally were engaged in crime together. I'm not sure it's obvious to me that the Sixth Amendment would create a flat entitlement to such cross, as opposed to that being, I mean, again, our cases have so many different formulations of the scope of the Sixth Amendment right. That's another smorgasbord to pick from. But I'm not sure that a judge wouldn't be able to say, if that's going to be really prejudicial, doesn't add much to, similar closely related evidence about the connections between or among this group of three people, I'm going to exclude it. I just think it's not so clear that that would be a Sixth Amendment violation or an abuse of discretion short of the Sixth Amendment.
I agree with that point. Were that the appropriate formulation of the bias? The reason why, and if we are switching to the Sixth Amendment, I do very much want to address Kavan. But speaking about the twins, just to your point, the theory of bias is not that, oh, they commit crimes, so they're lying here. the theory of bias is that they are biased towards one another, because when you commit crimes with people, you have a different level of relationship with them. You have a different kind of trust. You have a different kind of, you don't snitch, I don't snitch. And that is precisely the, what the cases recognize when they talk about, gang membership or being drug dealing partners, right? It's that when you are in a criminal conspiracy with someone, you're entrusting that person.
Why? Can you tell me why is it relevant that they're biased towards each other?
Because there's absolutely no corroborating evidence outside.
No, what I mean is usually bias is against the defendant, or if you mean they have a motive, a motive to, I'm just not quite sure that fits into the classical forms of bias I'm familiar with.
I mean, I think it absolutely does. I think that, the definition of bias as articulated by this court and the Supreme Court is.
So I'm sorry to interrupt, but let me just ask a hypothetical. So imagine the government calls two witnesses in a criminal case who both come in and say, I saw the offense and the defendant did it. And the defense wants to cross-examine them by saying, unrelated, you two, you're not charged with crimes or anything like that, and we're not trying to impeach you with a motive to curry favor with the government. We want to show that you are criminal Confederates. You sell drugs down on a street corner somewhere. Has no logical relationship to any of this, but we want to show your bias towards each other. Is that something the defendant has a constitutional right to do as among the government's witnesses?
Absolutely. I think because a bias is just any motive that could bear on your testimony. And if you, I think that you would not disagree that if you have two witnesses and they are sisters, that it's irrelevant that the government's witnesses have a familial relationship, because that could be their motive for corroborating one another, regardless of the truth, right?
Well, there's a fair bit of difference between what's relevant and what the Sixth Amendment creates a constitutional entitlement to explore. So I'm not sure that I would equate those. We've said a lot of things about the scope of the Sixth Amendment right to cross. I'm not sure we've ever said the Sixth Amendment permits the defendant to ask any cross-examination question that is relevant.
No, but it's not that it's relevant. It's relevant towards their motive to testify, where the entire theory is that this is a group of people who have colluded with one another and who are following Morris's instructions to testify. The fact that all of those witnesses come from the same sort of criminal cohort, I think is, I frankly find it hard to understand how that wouldn't be a bias.
May I ask you about this? I feel like I have three questions about this. One is whether this theory of bias was argued to the trial judge. The second is whether you can point to any specific questions that were asked of the witness where the witness invoked her Fifth Amendment privilege that bear on this particular theory of bias. And then, I'm sorry to overload you with this. And then the third question is whether, given all the evidence that these people were conspiring together, tape recording, or telephone recordings and all the rest, about in order to get the award and the reward and perhaps help Mr. Morris get out of jail, it would seem as if this is the theory, it hardly does. I'm just wondering what it really adds to what was already before the judge. So if you could answer those three, if you remember them, I'll try to remember them. If you don't. If you
Yes.
Questions, I'd appreciate it. The first question was this theory of bias, this bias toward one another because they commit crimes together, or some variant of it. Was that actually argued to the trial judge as a basis for allowing requiring the government to immunize these witnesses, or else forego their testimony?
Yes, I mean, first, well, as an initial point, the government does not argue that it wasn't, does not argue that we didn't preserve this theory. But also, I mean,
So I
this
should
was,
basically give you something you don't deserve because the government didn't, if it were true that you don't deserve it, just because the government, I don't know. But all right, the government doesn't argue it in their brief. Fair enough. But now tell me if it was argued to the trial judge.
I mean, I think that it was amply clear this was our entire theory of the case. And the trial court's reasoning, right, in its ruling is
No, I mean, what
precisely.
you're positing is Mr. Morris was Fagin to, you know, these little Oliver Twists, if I remember my, you know, I think that's right. And that's a different theory from what I had understood was being argued. I mean, Mr. Morris's role in instigating these people to, you know, go talk to the police and do all of that was all lovingly laid out in detail. But the notion that we have to be able to cross-examine the two twins about the criminal activity, these robberies and so forth, because we want to show that they and Mr. Morris are in some sort of criminal relationship. I just don't remember that being articulated to the judge, and but maybe it was, and that's what I'm asking.
I mean, I think that at least by the time we get to talking about Kavan and our desire to explore Kavan's relationships, I think it was quite clear that was part of what we were trying to admit, was that he was involved in these robberies, that he was,
Was Morris involved in those robberies? I didn't think Morris heard about them afterwards. The twins told him, according to the tapes, I guess. The twins.
Kavan told him about them, but I think it's relevant regardless of whether or not Morris is involved. But I think that this conversation can in some ways be clarified by focusing first on Kavan, because I think
fair enough.
Kavan is Morris's drug courier, and we were not allowed to explore that at all. And the obvious implication of Kavan being Morris's drug courier is that he's used to taking orders and doing his bidding, and that he obviously has a strong motive not to go against Morris. He has a strong motive to do what's in Morris's interests. And he, and the fact that he is then also a criminal co-conspirator of Morris's daughters, Kavan is sort of the through line here in a lot of ways.
But was this argument made to the trial judge as a basis for the bias cross-examination?
I think as to Kavan, yes, we made clear we wanted to explore not just his relationship with Morris, but we wanted to explore his relationship with the twins.
No, I understand that, but was the explanation given to the trial judge that here's why it's bias related, that it relates to showing that Kavan and Morris and the twins are in a criminal, de facto criminal family, with loyalties to each other and so forth that will affect their testimony. Was that actually?
Yeah, I mean, I guess I just returned to, I think it was when we were saying that we wanted to question Kavan about the fact that he had, related all of this in detail to Morris. I think that was clear, and it particularly based on our opening.
Well,
where we said,
weren't the tapes in evidence?
No.
Oh, they were not in evidence?
No.
They were not played?
No, because when we couldn't confront him with them, so there was no way that we could possibly authenticate them.
Can I ask you a framework question that we've moved over to the Sixth Amendment issue, and it's a little hard. I've had a hard time saying this simply, so bear with me if it comes out in a somewhat murky way. But I'm trying to figure out whether it's at all relevant that the reason that the trial judge refused to permit some of the questioning was because the witnesses were invoking a Fifth Amendment privilege. And then, of course, it arises in the question of whether the witness's testimony has to be stricken. And so I guess one way of putting the question is, should we analyze this case as though it's exactly the same as if the judge had just been sustaining objections to these, rather than with the analysis being somehow different? Meaning, can a judge say, look, ordinarily, if the witness was here and these questions were being asked by the defense, I would say the Sixth Amendment right would entitle the defense to ask that question. But I've got a problem, which is the witness is asserting the Fifth, so I can't make the witness answer. And now I've got a different question in front of me, which is, do I have to strike the witness's testimony? And that calls for a balancing that may mean that some of the questions the defense otherwise would be entitled to under the Sixth Amendment aren't going to be able to be asked because I have some latitude here. And I can say, well, there's enough here, given the balancing that I need to do between Fifth Amendment interests and Sixth Amendment interests? Or do you think there isn't really any balancing that's going on? And the issue of whether if the question is one that the defendant would ordinarily have a Sixth Amendment right to ask, the witness's testimony constitutionally has to be struck.
Yes, I think that is exactly what Isler makes quite clear, is that in the balance between the Fifth Amendment privilege of a government witness and the Sixth Amendment privilege of a defendant, the Sixth Amendment confrontation privilege of a defendant, you have to be able to explore, you have to be able to meet that constitutional threshold. Now, maybe what happens once you're past the constitutional threshold is a different question, but you have to permit enough to satisfy the Sixth Amendment. Otherwise, the government has to choose. Do they want to use the witness in this case badly enough to immunize them, or do they not? And that's a position that the government's in because it's their witness. And I think Isler is very clear on that, and very...
It may be my limitations. I found it a little murky, but I'll study it again, and maybe clarity will make its way through to me. But
well, I think before Isler, Johnson also makes this point. I think Johnson also says very explicitly there has to be sufficient cross-examination. I'm sorry, I'm forgetting the exact phrase, but there's a phrase in Johnson that says something like, once that basically there's no discretion until the Sixth Amendment threshold has been satisfied.
Can I ask you an aspect of this case that's puzzling me, and I'm wondering if you can explain it. A significant part of the limitation on cross seems to have been driven by Fifth Amendment invocations of witnesses. But there comes a time in the trial where the defense is trying to explore some of the, with the aunt of the twins, what she might know about the criminal problems the twin, or at least one of the twins might be facing. And the judge, there's an objection, and the judge says, sustains an objection. There's not a Fifth Amendment issue going on there. She doesn't have a Fifth Amendment privilege, and nobody suggested, relative to what she might know about the criminal problems that one of the two twins has. And the judge says, the nature of the charges, the underlying, I don't think are relevant. The objection is sustained. I found that seemed to be a puzzling ruling. And I don't understand PDS to have separately briefed that as a point of error. Maybe I missed a part of the brief, or I missed a point. But it just is puzzling to me. And I'm wondering whether you can shed light on whether you think the trial court got confused and didn't realize that the earlier rulings had been about the Fifth Amendment, or what's your take on that ruling, which again, I do find mysterious.
I think that ruling is significant because the trial court precluded this even when there was not a Fifth Amendment privilege at stake. So I do think it is significant, and we did discuss that in our brief. In terms of the timing, it was before the litigation about the Fifth Amendment privileges. And so I think that part of the assumption was that it could then be explored through Megan. I don't know, but the aunt testified before Megan.
You're quite right about that. I hadn't focused on that, but it makes it even more mysterious that later on, it's not really, no one's thinking about relevance anymore. It's all kind of Fifth Amendment privilege and striking testimony and the like. So anyway, I just find it puzzling.
Well, I think part of it is that by the time you get to Megan, you're also in a situation that is so, that Longus puts so squarely in the Sixth Amendment context, where you have a witness who then gets up and denies the bias based on, underlying facts that the defense is then not allowed to explore. And then
Counsel, you referred 2 or 3 times to the Supreme Court case law that says we have to identify a threshold of whether enough cross-examination has been permitted to satisfy the Sixth Amendment. Is it relevant to our inquiry that the finder of fact here was the judge who's articulating his thoughts on the record and articulated his thoughts in a written opinion later on?
Well, I think I'm sorry, Judge Fisher. I'm slightly confused by your question about whether I guess I'm not sure if you were talking about
often when a jury is involved, we're concerned about whether they heard enough so that they would understand and identify the potential source of bias. Perhaps when there's a trial judge involved, the judge will get the idea quicker with less questioning than it might take to educate a jury.
I think that, this court has always applied the same Sixth Amendment standard in bench trials as it has in jury trials. And I think that's for good reason. I think that you can't assume that a judge, if you're making determinations based on things that aren't, the judge making conclusions about things that aren't in the record, I think
I'm not talking about that. This judge knew that the questions were aimed to expose bias, and he appreciated at least some of the kinds of bias that were being urged by the defense. So he got it.
Well, he couldn't possibly have got, unless he was violating, the entire premise of a bench trial, which is that we believe that judges are in a position where they can hear proffers and hear evidence and tell the difference. As to the fact, what we think was the most critical bias, which was the fact that Cavan was actually Morris's drug runner. There was no confrontation about that. There was nothing in the record that the judge could have allowed himself to rely on. And the standard jury instruction that's given around the Fifth Amendment is you can draw no conclusions from the fact that a witness invokes the Fifth Amendment. You can't draw them for or against any party. You can't speculate as to what the underlying reasons for that are. And the entire premise of a bench trial is that a judge can simultaneously play the role of gatekeeper and fact finder, and we trust that they're going to abide by that rule. And I think that if you look at his opinion, his written opinion, you can see that the trial judge in this case did that, right? He's not saying, well, yeah, Cavan was Morris's drug runner, but I don't think that was influencing him. The only thing he says about it in his opinion is that that Cavan invoked the Fifth Amendment, and therefore he presumably draws no conclusions from that. So I hope that answers your question. But I do think that there's nothing different when it's a trial court versus a jury in terms of a complete preclusion.
To state that differently, you think it is irrelevant that this was a bench trial?
Yes, I think it's wholly irrelevant. I think that this court has applied the Sixth Amendment confrontation case law in bench trials. We cited a number in our brief where it said, where it applies the exact same standard. And I think an analogous situation, right, is that this court has declined to say that there's a different standard for beyond the ken of the jury and beyond the ken of the judge. I think that's a very good analogous area of law. I believe that's Tercio, but we cited it in our brief. And the court said, we can't do appellate review if we're relying on these sort of judge personality dependent standards. That's just not.
I'm talking more about things the judge has articulated. So we're not basing it on things that we know outside the record, but things that are in this record. We usually don't get from the jury any thoughts about suggestions of bias.
Well, and again, I think here, even if you do think it's relevant, we see that the judge here, the things that the witnesses claimed the fifth on, he did not consider them. They are not there is in his recitation of facts, there is a mention of the fact that the fifth was asserted, but then those things don't play a role at all in his decision-making. And he takes great pains to address the biases that he does think were presented. So I think here where you have a complete preclusion of cross-examining Cavan about his relationship to Morris, his being Morris's drug runner, and then also about his involvement in these robberies. Those were straightforward, complete preclusions that don't require us to get into the sort of murky area of Sixth Amendment. Was there enough questioning on this topic? Because there wasn't any questioning on the topic.
Thank you.
I'm well past my time, so unless
Yeah,
there are
we'll give you a
questions.
few minutes in rebuttal. Let us hear from counsel for the government.
Thank you, Your Honors. May it please the court. I am Samson Schatz for the appellee, the District of Columbia. After a 6-day bench trial, Judge Oken concluded that JW, the appellant, was guilty of felony murder, armed robbery, and other charges. On appeal, the defendant argues that the testimony of 4 separate witnesses should have been excluded. But as I hope to discuss today, those witnesses' testimony were properly entered into evidence, and thus JW's conviction should be affirmed. First, Megan and Melissa's testimony to Planchetta Jones on the day of the shooting were textbook excited utterances and were properly admitted as such. They were also admissible as prior identifications. Defendants' arguments rely a lot on speculation as to what took place, what the twins said or thought during the 5 to 10 minutes between the startling event and between the statements that they made to their aunt. But no such speculation is appropriate. And indeed, the court didn't engage in that sort of speculation in the court's most recent case, Parker, where the court found that a statement made by an individual who survived a startling event, when made 15 minutes later or more, after he had traveled to a convenience store at some unknown distance, but presumably fairly close to his apartment. There was no speculation as to what he was thinking or doing in those 15 minutes. The court said there was a startling event there that did cause him indeed to be startled. There was a reasonably short period of time, longer than in this case, and the fact that he was extremely nervous and agitated and upset were circumstances that contributed to the finding that his statements were spontaneous. And the court should do the same thing.
What do you make of your opponent's argument that potentially different from Parker, that leaving aside speculation or, from your opponent's perspective, failure to carry a burden, there is information here that the twins were taking like conscious, intentional, evasive action. They didn't want to be, identified and corralled by the police. So they leave the scene at their uncle's suggestion. And then I think the evidence was that later they come in, when they come back around, they come in through the back door in the hopes of avoiding the police. So that your opponent's argument is, we don't really have to speculate. This is not, one way of putting your opponent's argument is you don't have to speculate. There's direct evidence that they were consciously, taking steps about at least who they were going to be talking to about this incident, and that does point against spontaneity.
Your Honor, I don't think it does. The fact that
you don't think it even points against spontaneity, like weighs against spontaneity. You think that that's neutral at best for your opponent?
In this case, yes, Your Honor. For the fact that 15-year-olds, when told by their uncle to go down the hill to before the police come, I think the instinct to avoid an interaction with the police is not. It doesn't show a kind of a rational or a complicated reasoning for a lot of people in this country. And so I think the instinct to avoid an interaction with the police by going around the block, and of course, if they were trying to avoid the police or evade the police in any way, the fact that they returned to the house, the address that the police were being called to, was, of course, not a very kind of sophisticated way to do so. So I just don't think
they avoid the police on the day of, I thought, right?
Yes, correct, Your Honor. The police didn't talk to them on the day of, but I just don't think that returning to the house that the police have been called to is necessarily, number one in the book of how to avoid an interaction with the police.
When you say called to the house, that makes it sound like the police were responding in a way that would lead them to go inside the house. But I thought, to the extent they went to the area, they were going to where the decedent was outside the house, or am I misrecollecting?
Yes, Your Honor, but the decedent was laying on the side. The testimony in the record shows that the decedent was dying on the sidewalk in front of the house. But another factor that I think is misstated in the appellant's brief is that there was some sort of coordination with friends. The reply brief mentions that the twins met up with Chris and John, and that shows some level of coordination. The testimony actually, the record actually shows that Chris and John were with Megan and Melissa. This is on July 17th, transcript, page 151. Chris and John were with the twins, so there was no sort of kind of elaborate coordination with them either. So I just don't think that these guesses about what the twins were doing in these 5 to 10 minutes should in any way defeat the Judge Oken's conclusion that these statements were made when the twins were hysterical, screaming, and they didn't have an opportunity to think clearly about what they were doing. But next, Megan and Kevon Chandler's trial testimony was also properly admitted into evidence, despite the fact that they partially invoked their Fifth Amendment rights against self-incrimination. It seems in this argument that the defendant is now focusing on a theory of what they're calling kind of collusion bias. And a lot of evidence came in to the record and was used to impeach the witnesses about their ties with one another. And especially a lot of evidence came in to impeach the witnesses about the pernicious influence of Morris over his daughters and Kevon. There just isn't any support for the notion that the bare commission of crimes with other individuals adds such a kind of dimension to people's relationship that it leads to its own form of bias. I would just push back against the notion that that is a prototypical form of bias. If you look at the Supreme Court's case in Abel, where the court discussed the idea of collusion. The idea of collusion in that case was a witness and the defendant were involved in a prison gang that had as one of its tenets that they would lie on behalf of one another, or they would perjure themselves. And so the idea there, the reason that their criminal relationship was relevant was because it showed a propensity to manufacture evidence, obstruct justice, perjure themselves. And I'll point out that that relationship also pointed for or against the defendant. In that case, it showed, of course, a bias of the witness to testify falsely on behalf of the defendant. There's no such link here between the relationships between the twins and their father, Morris and Kevon, that points in any way, shape, or form to JW. And that's supported by something that the trial court specifically found, which is, I think in footnote 10 of his factual findings, that there was, that the twins actually, and Kevon actually had, were for all intents and purposes friends with JW before the shooting. So I think that's relevant to that as well. And
are you actually making a relevance argument or a harmlessness argument? Relevance is the wrong word. Are you making an argument that there was no legal error at all, no confrontation clause problem at all in excluding this testimony, or are you making a harmlessness argument there because there was substantial other evidence of the relationships between the members of this group?
I think you can interpret us to be making all of the above, Your Honor. The fact of the matter is that I don't think that the defendant has just by suggesting that these individuals have committed crimes with one another, that they've proffered enough facts to establish a theory of prototypical bias. And so I don't believe that there is a confrontation clause right to have.
I mean, if the government's evidence, look at it this way. If the government's evidence is Morris set in motion this plan to implicate JW, and ladies and Your Honor, I want you to, one reason I want you to believe that it's false is because you should not take much faith in the fact that Kevon testified in support of it, because Kevon is Morris's henchman, and we want to bring that out. Now that's sort of a rough way of saying his being Morris's henchman would be relevant to whether to evaluating the bias of Kevon's testimony, right?
Several points, Your Honor. First, I think it was already thoroughly examined at trial, the close relationship that Kevon and Morris have to one another.
Well, as counsel points out, we have to draw distinctions, which I've tried to draw as I read through the testimony, not always easy, between what is being proffered and what information is contained in a question, and what information is actually contained in the answer that's submitted in evidence. And there are some significant differences there. The judge can't assume everything in the question is factual, supports the finding of fact.
For sure, Your Honor, and we're not suggesting otherwise. There just was the close relationship between Kevon and Morris was thoroughly examined. The fact that
did the government take the position in the trial court that yes, it's true that Kevon is basically the father's minion? He's kind of his subordinate, minion / henchman / criminal employee. I assume that wasn't conceded, and the government, I assume, was asking the judge as a fact finder to credit Kevon's testimony, notwithstanding that there were these disturbing conversations involving Kevon and the twins and the father that could lead you to think, wow, maybe he's being unduly influenced into making an allegation against JW in order to benefit the father. And it seems to me, I mean, again, if it weren't for the Fifth Amendment, there's a pretty good argument that it's relevant, and maybe so relevant that it ought to be permissible questioning, barring, of course, that the Fifth Amendment added some procedural complexity to all that.
So 2 responses, Your Honor. First of all, again, I do think it was thoroughly examined that Kevon could be influenced to testify in a certain way under.
Well, can you say, like, what was actually elicited as a result of that examination?
That Kevon was so close to the twins and to Morris that he had developed a relationship with him, called him regularly at the prison, considered him like an uncle. Again, I don't think that there's any support in this court's case law to suggest that the bare commission of crimes leads to a separate theory of bias that then creates a Sixth Amendment confrontation clause, right? But I also want to just make a quick kind of aside about the amount of information we know about Kevon and Morris's crimes together. As opposed to the robberies for which a substantial amount of factual predicate was proffered, the defense counsel just kind of out of the blue started asking questions, and I think asked 5 questions about Kevon's criminal, errand running with Morris. Part of the reason that we don't know, any of us, the trial court, all of us here, don't know more about the details of that, is that the defendant didn't meet its burden of proffering a sufficient factual predicate.
Was that the basis of the trial court's ruling? Did the trial court say, well, I would allow this questioning, but there's not an adequate proffer?
No, but there wasn't. There wasn't really a ruling that's being. There wasn't a ruling by the judge that's being reviewed here. It was the Fifth Amendment invocation. So Kevon invoked his Fifth Amendment.
The ultimate ruling that's being reviewed is the judge's refusal to strike the testimony because there was, in the defendant's view, inadequate cross. I thought that was the ultimate ruling.
So I think that the claim is that the invocation of the witnesses of their Fifth Amendment right blocked the defendant from pursuing certain lines of questioning. And I think that's what we're focusing on here. The court has said, this court has said in several cases, McClary and others, that that if the court finds that an error was committed in terms of closing off a certain line of questioning, that the proper way of conducting a harmless error analysis, for example, is to hypothesize that line of questioning could have been or would have been pursued, and then to evaluate how that would have affected the witness credibility or the trial as a whole. So I don't think that it's just a question of whether or not the witnesses should have been struck.
Well, I mean, the judge couldn't have compelled the witnesses to answer the questions as to which it's undisputed for current purposes, as far as I know, that they were validly asserting a Fifth Amendment privilege. So the only options would have been, declare a mistrial, strike their testimony, both preclude their testimony, the rest of their testimony. Well, I'm not quite sure. Are you saying you don't think it's the right way to analyze this? Well, actually, let me step back and ask you the same question I asked your opponent. Is it your view that really the issue here for us is, analytically, we could just think of it as, imagine the judge just said, no, you can't ask these questions. And the issue is whether that would be okay or not okay under the Sixth Amendment. I think your opponent's argument is that's the way we should look at it practically. Or do you think instead we should be saying, well, maybe ordinarily the Sixth Amendment would have entitled an answer if that were true. In some case, that might be true. But sometimes the fact that it's arising in this Fifth Amendment setting may give the judge a little bit more or significantly more latitude to balance interests. Do you think it's the former, as your opponent does, or do you think it's the latter?
It's the latter, Your Honor. I think the court has made clear that when the Fifth Amendment, when a witness has invoked his Fifth Amendment rights, the analysis, the calculation is different. The court talks about a balancing of Fifth Amendment and Sixth Amendment rights. in McClellan, this court speaks about the fact that the details about a given, potentially bias-inducing event could come in through another witness or other documentary evidence, and so that is a way to balance those Fifth and Sixth Amendment rights and to defeat a Sixth Amendment Confrontation Clause claim. And that's relevant here because I think witnesses gave us different information about the robberies, for example, and stitched together, that was a tremendous amount of detail about those robberies. Your Honor, there's claiming that the judge made an evidentiary ruling that violated the Sixth Amendment right, and that the witnesses invoked Fifth Amendment rights in such a way as to violate the Sixth Amendment rights are two separate types of claims. And the defense—
Can you help clear up a mystery about one of those two things? Because as I indicated in questions for your opponent, I found myself a little puzzled by the trial court's ruling about the scope of cross-examination of the aunt, about what the aunt might know about criminal conduct by one of the twins. There was an objection, and the trial court said the underlying, and the defense said explicitly, we're trying to show kind of the magnitude of, didn't say explicitly, through extrinsic evidence, but that's an okay way to do it for bias. We're trying to show the magnitude of that twin's motive to curry favor with the government. And the trial court sustained an objection and said the nature of the charges, the underlying, I don't think are relevant. That has nothing to do with the Fifth Amendment, you would agree?
Correct, Your Honor, and that decision by the judge is not under review here.
Do you think it was correct?
I haven't looked into the question thoroughly, so I don't want to go on record as saying that I thought it was correct. It's just not under review here. Yeah. But I just want to make sure that I get a chance before I see my time.
Yeah, one more question for me at least. And as a spoiler, it's a question I may well ask on a rebuttal of your opponent. Leave aside the complication of the Fifth Amendment, but just generally in describing what the scope of the Sixth Amendment cross right is. Our cases have a lot of different formulations. You can see things about meaningful cross-examination or enough to make the argument or discriminating appraisal or not cutting off an entire topic, whatever an entire topic is, what level of generality is a topic, not so clear to me. Is there one that you think is the one that we're bound, if those are different as they seem like they potentially might be, is there one that you think is the right one that is binding on us that we should be applying, or do you think they're all the same, or what's your take on our various formulations?
I think that the court got it exactly right in McClellan when it said that the defendant is entitled under the Sixth Amendment Confrontation Clause to pursue a theory of bias in such a way as it would give a significantly different impression of the credibility of the witness to the fact finder. And I think that's very similar to what the court has said in other cases, like Lewis. The court said Constitution is satisfied so long as counsel was permitted to elicit enough testimony from the witness to argue that the fact finder was biased. But I think it can't be that the Sixth Amendment entitles a defendant to pursue anything that it can call a bias. It needs to be something that will give the fact finder a significantly different impression of the credibility of the witness. And I also think that the amount of detail that comes in about a theory of bias needs to be commensurate with its probative value. And in this case, I think that threshold was absolutely met.
Let me ask you whether it is crucial for the Sixth Amendment analysis that the information relating to bias come out during cross-examination. Let's assume cross-examination is completely foreclosed on that topic, but the resourceful defense attorney calls witnesses and presents extrinsic evidence laying out the theory of bias. Do we analyze that under the Sixth Amendment, or is that something else?
Your Honor, that's absolutely something that McClellan says this court can do. the court said where one witness invoked his Fifth Amendment so as to avoid answering questions about a prior shooting, another witness was immunized and did give detail about that prior shooting. And so your Honor is absolutely correct that especially when you have Fifth Amendment rights and Sixth Amendment rights in the balance, this court has said in McClellan that you can use other extrinsic evidence, other witnesses, other documentary evidence to establish the details of that potentially bias-inducing event in order to satisfy the Sixth Amendment Confrontation Clause.
You say especially when, and I tend to be pretty skeptical that if that's okay, that may be a special rule where there's a Fifth Amendment, Sixth Amendment problem, because it can't be generally right that if I'm the defendant and I want to confront a witness and have the fact finder see how the witness responds to impeaching questions, including bias questions, it can't be right that ordinarily the Sixth Amendment right is met as long as the defendant has a right to put on some extrinsic evidence that would support the questioning. I mean, part of the whole idea of cross is that the constitutional right to confront witnesses is that you confront the witness, not that you introduce extrinsic evidence so the jury can consider it. So it can't be a general substitute for the cross-examination that the Sixth Amendment entitles you to be able to introduce extrinsic evidence on the topic that you wanted to ask the witness about but weren't allowed to.
Perhaps, Your Honor, but this is a case in which the claim is that the witness's invocation of their
you say perhaps. Do you actually think that there's any reasonable debate about that? Or do you agree that that must be right? Or you're not sure?
That sounds, it sounds very convincing when you say it, Your Honor. Again, it's not a question that I've thought about because this case is a case in which the claim is based on the invocation of Fifth Amendment rights. So I've been focused on what the courts have said about how you handle these Sixth Amendment claims in the context of a witness's Fifth Amendment invocation. And we know from McClellan that that is an appropriate way in order to satisfy, an appropriate way to get details in about a specific event in order to satisfy the Sixth Amendment Confrontation Clause.
Tell me more about McClellan. It's been a while since I've read it. Did we say that the extrinsic evidence meant that there had not been a Sixth Amendment violation? Or did we say that the curtailment of cross-examination, impermissible as it was, turned out to be harmless because the extrinsic evidence filled the gap?
It was the former, Your Honor.
Thank you.
Before you sit down, I wonder if you'd like to comment on this. Suppose we were to conclude that Cavan's testimony should have been stricken because there was just too much bias cross-examination that was precluded by his invocation of the Fifth Amendment. But we don't reach that conclusion with regard to the twins. Would you say that the error in not, I mean, you know, I know what you want to say. I want you to, if you want to say that, well, the error in failing to strike Cavan's testimony was harmless because the government's case was tremendously overwhelming, even without it. On the assumption you want to say that, do you want to take a few moments to defend that proposition?
Thank you, Your Honor.
Or if you want to admit that without Cavan, it was not overwhelming, you'll save us all a lot of trouble, I suppose, but so you have a choice.
No, I absolutely do think that if this court determined that Cavan's, that the defendant's Sixth Amendment right to confront Cavan was violated, first the court needs to ask whether or not the additional lines of questioning would have further called into question the credibility of Cavan, and I would argue that it wouldn't. But I take your Honor's question to say,
I think the presumption of saying his testimony should have been struck is that we no longer worry about the credibility of testimony because it shouldn't have been in there at all.
Well, just to push back on that a little bit, Your Honor, this court has said that where a line of question, or where the defendant's Sixth Amendment Confrontation Clause right to pursue a certain line of questioning, where that their right was violated, the court still will determine whether or not, if those questions were asked, it would have made a meaningful difference as to the fact finder's assessment of the credibility of a given witness.
Yeah, I was sort of skipping a couple of steps when I said strike. What I was thinking of, maybe I should have made this clear, is that when we address the question of harmlessness of a Confrontation Clause violation like this, we assume that the damaging potential of the, precluded cross-examination would have been fully realized. And what that means, there are two ways to look at that. One is assume that the witness's testimony would have been seriously weakened, but the other way is to say, assume the witness, what would the case look like without that witness? And I'm really on that prong of the harmlessness inquiry that was what I was thinking of when I asked that question.
Yeah, absolutely, Your Honor. And the answer to that is also that there's a very good argument that it would have been harmless. This court acknowledged in Martinez that a witness's testimony was only 5 pages of direct testimony, and that helped measure the kind of value of the witness. Kavan's testimony was less than 20 pages in an otherwise very lengthy trial transcript. So I think that helps provide some sort of kind of numerical calculation. But beyond that, there of course is the witness. There was Megan and Melissa's testimony. There are their identifications from March of 2018 at the U.S. Attorney's Office in blind photo arrays and grand jury testimony in which they identified JW. There's, of course, their statements to Planchetta Jones, their aunt, that came into evidence. There is some ballistics evidence that helped corroborate their testimony and their description of the events. So I think there is absolutely enough evidence here to uphold the conviction, even absent Kavan Chandler's testimony.
Do you recall how much Judge Oken, in his opinion, I just don't remember this clearly enough, relied on Kavan? I don't know why I said it like Kavan.
Hard to kind of assess, but I don't think that Kavan was, I think Kavan was not central to the judge's conclusions. Again, I think there was enough evidence that came in through Megan, Melissa, their prior identifications, and Planchetta's testimony, as well as some of that ballistics evidence to uphold the conviction. And if there are no...
Notwithstanding the evidence that there was a sort of a conspiracy among Morris and the twins to try to get something good for themselves out of this opportunity.
Well, that was, yeah, exactly. Notwithstanding that fact, the judge acknowledged that Morris had his own plan, was trying to kind of finagle things to get himself out of prison earlier.
We have to be able to say that if there was an error with regard to Kavan, it was harmless beyond a reasonable doubt.
And I believe that this court could do so.
Strong standard. Okay.
If there are no further questions, we urge the court to affirm. Thank you.
Okay, thank you. Ms. Pavlovich, would you like to rebut for a few minutes? You're mute, I think.
My apologies. That is correct. Yes, I want to specifically focus this court's attention on Kavan because there was a complete preclusion of the cross-examination about him being Morris's drug runner, and the government doesn't argue otherwise. All it says is you didn't need that because you had quasi-familial ties. That is directly contrary to what Blunt says, to what McCleary says, to what other cases say that say where you have a distinct event probative of bias, that you have to be able, the complete preclusion of that bias, the exploration of that bias is an error of constitutional dimension. And As to harm, the government, first of all, nowhere in its brief argues that if Kavan's testimony needed to be stricken in its entirety, that error was harmless. It does not make that argument in its brief. But in any event, it cannot make that argument. The government's entire case was, you will know what happened because these 3 witnesses saw it. Then, because its witnesses were so compromised, it chose to call only 2 of them in its direct case. And Kavan, as he appeared to the trial judge based on the facts that actually were in record, was the one non-family member who was testifying in this case. And, you know, you may have gotten some familial ties or whatever, but Kavan said to the judge, when cross-examined, why would I lie for him? That's not my father. Well, if the evidence had been that he hadn't, that he was his drug boss, that his credibility would have been shot on that point. And there's just no way that saying in a case where the physical evidence points to someone else, because there's DNA under the decedent's fingernails that does not match JW, somebody else has the gun and also possibly the decedent's sneakers, that knocking Kavan's testimony out, the only non-family member, that would not have affected the trial court's verdict. I mean, the trial court relies on all 3 witnesses' identifications, on all 3.
Counsel, a lot of your, what you call bias, cross-examination, your theory, goes to the motive for testifying. Could you clarify for me why you think Mr. Morris had an interest in falsely identifying JW as opposed to getting reward money and getting himself a reduced sentence?
Yes, I think our theory at trial, as we explained it, was, you know, there was evidence of some amount of animosity between them. Planchita Jones was on the phone with Morris complaining about JW picking on the girls, and that everyone in the Morris family knew that the Morris and Jones family knew they had to name somebody in order to get the reward. And so why not name JW? Melissa is on the phone with Morris saying, I don't know what happened. That's why we all have to get together and make up one story.
Is it partly your theory that they actually didn't know who committed the shooting? And it's not so much that they had, it's not only that they may have had some bias, some antipathy towards JW, but also in any event, they had to make up somebody. And so, it was JW's unlucky day. Is that the idea?
I think that there were 2 theories. I think one was just as you put it, and the other was, well, they originally said to Morris on the phone, older guys from the neighborhood who, in fact, that matches the description of the people who were later found with the gun. And, maybe they were more scared of those people than they were scared of JW. Or JW was a juvenile, and those kids.
Well, there were apparently 2 assailants of the decedent. One thing that I've sort of thought about that cuts against this particular argument is that, if you're in the position of the twins and Morris, the notion that you would just take a stab in the dark and name someone who you knew was not the person who committed the killing. That's a hugely risky thing to do, because you don't know whether the police have already, investigated this and suspect someone else, or ruled out this particular person who was on the scene. For all you know, they've arrested somebody else already. They're taking a huge gamble if they don't really believe JW was the assailant. That is, to my mind, a factor that supports the judge's conclusion to find them credible. I'm not putting more weight on it than I think it should probably bear, but I think it is a fact.
I mean, I think that it's obviously a harm argument and not an error argument, as the government kind of posits in its brief. But you know, at the end of the day, it is not the defense's burden to prove who did this, right? And all we had to do was convince the judge that these witnesses, you can't trust their uncorroborated word. And one of the ways that the government's corroborated the twin story was to bring in Kavan, who was a non-family member. And in fact, he was one of only 2 witnesses that they ended up calling. And the judge's entire reasoning for why he chose to, he said, absolutely, Morris is completely corrupt, but his motives are his motives, and the teens' motives are their motives, and I think you can draw a clean line between them. Showing that Kavan was Morris's drug runner unquestionably filled that gap and said, no, there's more going on here. You cannot separate out Morris's corruption from these twins, from these teens so easily. And again, I think that the result, if the damaging potential had been fully realized of that cross-examination, it would have been devastating to the government's case. Because it would have provided precisely that nexus of the government that the trial court ultimately sort of hung its determination on. But then also, if Kavan's testimony isn't there, this is a case where there is somebody else's DNA is recovered, the gun is found with somebody else, that person also appears to maybe have the victim's shoes. This is not an overwhelming government case by any stretch of the imagination. If you look at this court's case law assessing harm in a situation like this, it hands down the presence of outside corroborating evidence besides just witness statements is one of the first things that the court points to if it finds harmlessness, and one of the first things it points to if it finds that it was not harmless. And I think that you have that here. You have a situation where if Kavan was out of this, it boiled down to, do you trust these 2 sisters who are on the phone saying things like, I don't know what happened, that's why we got to get together and make up a story. And in a case where there's nothing objective linking JW to this case, it is absolutely impossible to say that it was harmless beyond a reasonable doubt.
Can I ask you a legal question? The legal question I asked your opponent, and I foreshadowed I might ask you, which is, if we are writing an opinion that says, here's what the Sixth Amendment standard is, we, it seems to me, have a number of formulations floating around in our cases. And your opponent said that the one he thinks is appropriate is, I'm paraphrasing a little bit here, but, would the cross-examination have made a significant difference to the jury's fact finder's assessment of the witness's credibility? Is that a standard? I'm sure you think you could win under that standard. So for purposes of this case, if that's a standard, I'm sure you think you would win. But do you agree that that's the standard that we should sort of, if we were writing an opinion saying, we've said a lot of things, but here is, the best formulation of it. Here's the one that should, kind of be our focal point going forward. Do you agree that that's the best formulation, or would you pick a different one? And if so, why?
You're muted.
Versus legal standards. I think that it's not the best formulation. I do absolutely think that we win under it. I think it's not the best formulation because it comes from Van Arsdal. And Van Arsdal explicates what it means when it says that, because it says that standard is precisely why complete preclusion of a prototypical bias is a constitutional violation, because it necessarily would significantly impact the assessment of the jury's assessment of the credibility. I think that this case, to me, falls under the line of standards, fits most easily in the line of standards articulated beginning with Jones and then Blunt and then McCleary, where it says, the complete preclusion of a distinct event giving rise to a prototypical bias is a
Can I ask you about that? So
six-month
is that a quote distinct event? Is that that's the term we use?
Yes, that term
Distinct event.
originates in Jones, I believe. And that's precisely what the court in Blunt said. Yes, you got to cross-examine this witness about all the sweet deals that he had regarding his involvement in this case. You got that his case was no papered. You got that he, expected to get off scot-free for his involvement in this case, but you didn't get in that he had a pending Maryland step docket case for a misdemeanor. And that is a distinct event going to a prototypical bias.
So if I'm cross-examining a witness who I want to show hates the defendant, and I have several hundred instances where the witness said, I hate the defendant. And I want to ask the witness about all 100 of them, and I want to put on extrinsic evidence of all 100 different dates where the person said, I really hate that person. You're saying the Constitution requires as a flat rule that every one of those distinct events going to bias has to be admitted. And it's a constitutional violation if the judge lets in only 90 of them.
I mean, I believe that essentially that is what McCleary says. I doubt you would ever get a case like that. I think McCleary says, yes, it's a constitutional violation if you have 5 pending charges and you don't get into the 6th charge, and you have a constitutional violation. But in that case, because they're at a certain point become cumulative.
And you think the word distinct means only separated in space and time rather than carrying with it some different sense of meaningful difference, a very vague concept. But you just mean factually distinct. You don't mean kind of conceptually distinct in some way.
I think that so one way the court has articulated it is event, and another way the court has articulated it is source. And so, there may be, depending on what the particular bias is, you may be able to say, okay, you have all of this is all one source, and you don't need to illustrate every single instance of it, right? But that's just very, very far from what we have here. Kavan's relationship with Morris was totally different in kind. It was both the evidence that we had of it was both a distinct event, and it was different in kind from anything else that we got in. So, I think that whether you think about it in terms of being a distinct event, or whether you think about it as being a distinct source, I think that under this court's rulings in Jones and Blunt and McCleary and the like, it is a Sixth Amendment violation. And here, for the reasons I said, it's not harmless. Court has no further questions, then we would ask that the judgment below be reversed.
Okay, counsel, thank you very much. The case is now submitted, and you're free to log off.
Thank you, Your Honor.
Give me a moment if you would. Thank you. We'll call the third case, George versus District of Columbia. I think one counsel is still connected, if I read this correctly. Hold on one second, please. All right, I don't think Ms. Pittman is actually arguing, so, okay. Counsel, you may proceed.
Thank you, Your Honor. May it please the court, my name is George Dumar. I'm here arguing for appellant George Farris in this matter, number 19-552, seeking to have the summary judgment entered by the trial court on May 21, 2019 to be reversed and remanded, the case remanded back to the trial court for proceedings. Your Honor, this case involves claims that the district negligently maintained an alley and that in 2015, or about December 24th, the alley or portions of it basically imploded into the basement of my client's house off the 8th Street corridor in Washington, D.C. At that time, by that time, the district had notice from a call on August 19th, 2015. There were problems with the alley, that it was in repair. Again, on September 26, 2015, there was an inspection of the alley noting that it needed repairs. Finally, the alley imploded on December 24th. Mr. Farris sent in this notice on January 2nd, 2016, noting that there was hydrostatic pressure collapse into his house on December 24th. We believe, Your Honor, that under section 12309 of the District of Columbia Code, which is the applicable section here, says that, as the court knows, an action may not be maintained against the district, unliquidated damages to person or property, unless within 6 months after the injury or damage was sustained, the claimant has given notice in writing to the mayor of the District of Columbia of the approximate time, place, cause, and circumstances of the injury or damage. Your Honor, our position is that—
Mr. Dumar, if I could interrupt you for just 1 second.
Sure, Your Honor.
I'm noticing, and I assume I'm not alone, that there seems to be a fair amount of feedback during this argument.
Oh,
that's making it a little bit harder for us to hear you.
Let me,
or at least for me to hear you. So if anybody is listening and not muted, please mute. That may help.
We'll try to do.
I don't know, unless it's something on your end, in which case we'll just have to.
Well, what we're going to try to do is, I think someone was listening into my office. We'll try to get them to move to another section. And see if that
thank you. That would be good.
Addresses the problem. We've had that with other circumstances where we have web-based portal arguments, Your Honor. So we'll try to address that.
Thank you.
Mr. Dumar, can I ask you a threshold question? Do you think of this as a case about when an injury was sustained or when damage was sustained or both? Or do you think there's a difference between those two terms? They both apply to your case? Which one are we talking about, or both?
Well, I think because it's a property damage case, Your Honor, I think it's, I don't know that there's a difference between the two terms in this context, Your Honor, that there was, certainly we're claiming there's a, under traditional sort of evaluation, it's a property where the alley caved into my client's house would typically be evaluated on the case basis of damage, but I'm not sure it makes a substantive difference in this case, Your Honor, whether it's injury or damage. I think the same analysis applies, that you have to suffer this injury or damage. The injury or damage that my client complained of in his notice occurred December 24th.
Well, I just wonder, do you think the word, relatedly, do you think the word injury in that statute is limited to physical injury to a person in contradistinction to property damage, or do you think it could be a reference to economic injury such that your client may well have sustained on the date of the collapse both an economic injury and property damage?
Well, I think it would be on the date of the collapse, economic injury and property damage, Your Honor. I think the statute, I looked through the cases over the last week, and go back to the Shaheen versus District of Columbia case, Judge Nebaker in 1978 looked at the legislative history, and the legislative history was that this statute sort of arose out of a effort to allow plaintiffs to sue for accidents. And so I think that it initially was a statute that was developed to apply to accidents and would have like personal injury. But over time, the DC Court of Appeals has confirmed that the statute applies to a broader range of claims than just accidents, whether it's medical malpractice, whether it's other kinds of torts, whether it's economic claims arising out of leases or other contracts, or potentially even employment claims. I think the statute has a broad application. But I think if you read the statute and just apply the words of the statute, my client is entitled to bring the suit because he provided notice clearly within 6 months of that implosion into his basement. Now,
Counsel, let me ask you, I'm not real wild about the government's argument that the time started in 1980 when there was water seepage, but there are at least 2 instances in more recent years where your client declared that this same cause had rendered his house uninhabitable. And why shouldn't those events trigger the time frame in 12309?
well, Your Honor, I was thinking about this question because I think if those events triggered the time frame in 12309, my client did comply with it because, actually, as the district has pointed out, he provided his first notice on December 1st, 1985 of a problem. So to the extent there was issues
I understand that I understand the district says those notices did not comply with the statute.
Well, Your Honor, I think if you go back to that first notice, it's a little vague because of what was going on back in 1985, that there wasn't really any damage or injury at that time, in my view, Your Honor. There was potentially seepage that had taken place that may or may not have really been from the district's alley. But I think that if you look at the court's history, whether you go to the Shaheen case from Judge Nebaker, although the court has kind of strictly applied the timing requirement of the 6 months, the court has more generously applied the general notice requirement, Your Honor, that once a plaintiff can sort of make the basic claim of some injury or loss provided to the District of Columbia, that should be sufficient. And so I believe that going back to 1985, the notice that Mr. Farris provided was sufficient at that time, although he really hadn't occurred.
But I mean, that's sort of not a direct response to, I mean, Judge Fisher's question or an aspect of it was, are you implicitly conceding that if you hadn't given notice at those earlier 2 times when the house, whether it was the time they had to put up the steel girders and the time on uninhabitability, are you conceding that if you hadn't given notice then you would be out of luck now?
No, Your Honor, I'm actually not. My position is that we gave notice in January of 2016 for the injury that occurred in December 2015. That's sufficient. But our backup position, Your Honor, and this is interesting because there were cross motions for summary judgment. The district didn't raise this issue. Judge Rigsby denied summary of judgment to the district and ruled in our client's favor on the continuing tort doctrine. And it's only then, this is an odd posture, that the district comes in and says, wait a minute, you didn't give us prior notice under 12309. In fact, Your Honor, our client had given prior notice 30 years prior to that, literally 30 years prior to his basement caving in.
Can I ask you how you, I mean, I find this case hard, these flooding cases, and there are a lot of them around the country in various different permutations that are mostly statute of limitations cases as opposed to arising under a notice provision like this. So they could well be different. But here, let me ask you a hypothetical that also touches on maybe the idea of continuing tort. So imagine that, I own some undeveloped property right next to an alley, and when rain hits the alley, because the district didn't design it right and doesn't maintain it correctly, it runs onto my property. And, every time there's a storm, I lose, some more topsoil. And I noticed that on day one, the day I buy the property, there's a rainstorm, and I see, oh my God, the water is running off this alley, and it's not properly designed, and it's eroding my land. And, so over the next, 30 years, there are, 7,000 rainstorms. And depending on the size of the rainstorm, I lose more or less of my property to erosion. And then, finally, I get fed up. Nothing big happens on this day, but I get fed up. And within the 6 months of the most recent rainstorm, I sue the district in tort. And I say, I want, and over the years, I've lost I've suffered $25,000 worth of erosion damage. Is that a timely notice? If I send the notice, within 6 months before I then file a suit?
Well, I believe, Your Honor, that would be a timely notice given, I think it would be a timely notice because I think under sort of a continuing tort theory, the damage that you look at as a continuing tort doesn't really arise until the tort conduct ceases. And in that
some continuing tort, some courts in some settings will allow a continuing tort to bring in what would have been outside the statutory period as part of an ongoing course of conduct. In other settings, some courts will say, no, we kind of divide things up and we will permit recovery. And this is usually in the context of statute of limitations. Again, it's only an analogy to our notice provision. But they'll say, well, okay, you can, you can recover for the damage, for the injury that was sustained during the statutory period. And by analogy here, one could say, if you're thinking of it that way, that your notice would be valid with respect to the aspects of this, intermittent and gradual drop by drop injury that occurred chronologically within the last, within 6 months of your notice, but otherwise you didn't give adequate notice. What would be wrong with, and that might well favor you here, that analysis. It might not, it might require some parsing of exactly what happened when.
I think that's the approach that Judge Wilkins took in Motley Ivy versus District of Columbia, Your Honor, 923 F second, sub second. In the context of a continuing tort or ongoing claims, Judge Wilkins in the federal court said, look, you have a continuing tort for purposes of the statute of limitations. That allows you theoretically to claim going back to the beginning of the adverse activity, but the 12309 notice is a little different. And that's more strictly construed. All the exceptions to the statute of limitations, the accrual requirements, that doesn't necessarily apply. So the judge ruled in that case that the plaintiff could only go back 6 months prior to her first provision of a notice. And so that sort of cut off some of her claims. The good part about that case for us, Your Honor, that I didn't think about until this week was, well, this is an unusual case because Mr. Farris has been providing notice for 30 years and nothing happened. If we are limited to claims that arose from 6 months prior to the provision of his initial notice, well, his initial notice was provided in December of 1985. So effectively, I think, if we apply Judge Wilkins' analysis, which is essentially what Your Honor just said, that you go back for 6 months prior to this notice, I think that's my compromise position, but it also works for us because it goes back, Your Honor, to 1985 when the first notice was provided. So my client's been providing notices over time. It's a very unusual circumstance, Your Honor, where the summary judgment was initially denied for both sides. This claim as to 12309 is made that, gee, as a policy matter, the district under 12309 should get early notice of these kinds of claims so they could try to take remedial action. And in fact, my client had been providing notice for 30 years, Your Honor. So I think there was plenty of early notice for the district. The purposes of the statute were served. And I think that the January 2016 notice is sufficient relating to the damage on December 2015. But even if that's not the case, if we're limited, as Your Honor suggested, to the time period for the initial notice, preceding 6 months preceding the initial notice, the plaintiff should still get to go back to 1985 when his initial notice was provided. And that would be sufficient to basically give my client full relief. I mean, he has to deal with the statute of limitations issues and how that's interpreted. But actually, Your Honor, on the continuing court theory, I believe that's the law of the case here. Judge Rigsby ruled in favor of our client for statute of limitations purposes on the continuing tort theory on April 19th, 2019.
Are you suggesting that we're bound under the law of the case doctrine by the trial court's resolution of that topic?
Well, there was no appeal of that order, Your Honor. So I think that is the law of the case. What happened here?
Well, it's not by itself an appeal. It wouldn't by itself be an appeal order, would it?
Yes, it would, Your Honor. That order could have been appealed. Could have been appealed by any party. That was the initial summary judgment motion was denied for both sides.
Well, an order denying summary judgment isn't ordinarily appealable because it contemplates further proceedings in the trial.
Fair enough, Your Honor. And we did have those further proceedings. But once the proceedings are final, then I think you can appeal the adverse decisions that took place in a case. So I think the government was...
Well, probably not that either. I mean, the district prevailed, so they can't really appeal from a judgment in their favor. I guess what they might be able to do is in that they might have been able to argue alternative grounds for affirmance in this court. But I don't know that they could have noted an appeal from a ruling in their favor.
I've seen that happen before, Your Honor, after a case is over, as a matter of cross appeal when the losing party ultimately appeals. But I understand Your Honor's position on this. I mean, I think that the court, what's in front
And can I ask you on this idea that if it is a continuing, if ideas like continuing tort are relevant to 12309, and the issue would be maybe there was, to the extent you would have adequate notice with respect to physical consequences at the location that occurred in earlier years, there would be issues about when notices were given, whether they were received by the district, whether they were adequate in substance. I mean, the trial court didn't work through any of that in detail. And so that would have to all be sorted out on remand if you were otherwise entitled to some relief here. Is that, you agree with that?
Yes, Your Honor. I do think some of that would have to be sorted out. And I think that's the issue. There are factual disputes because although our position is that the notice in January of 2016 is sufficient for the damages, that in fact, our client's been providing notices going back 30 years. So the district had more than adequate notice. It goes back way beyond a time frame where our client really had any injury or damage here. So I think that would have to be sorted out by the trial court. Probably should have been sorted out by the trial court, in its analysis here. And I would say, Your Honor, looking at other cases, there is actually an alley case in the District of Columbia. Fowler v. District of Columbia is out there, 497, 8th 2nd, 456 from 1985. In that case, there was a problem with the alley. Mr. Fowler noted the problem with the alley soon after he moved into the house. He was having cracks in his house. Some of his workmen said, well, your cracks are coming from problems in the alley that's not properly built. And he didn't raise the issue for 14 years with the district.
Well, the difference there is that I think the court focused on whether he was really aware that the cause of the injury he was sustaining was the district's neglect. Here it's evident that Mr. Farris has known for many years that the district was the source, the district's failure, the district's configuration of the alley was the source of his problem, and yet he did nothing. Now, you say he gave notice. I don't know that the record really is clear on whether he gave notice in the proper way for 12309. I think, but let's assume for the sake of discussion that the first notice he gave to the district was in December 15, after his wall imploded. The district's argument essentially comes down to the notion that there weren't different independent injuries here. The December 2015 injury was not an independent injury from other prior ramifications. Rather, there were, over the course of some 30 or 40 years, different manifestations of a single ongoing injury. And our case law points to the notion that when that's true, the 12309 requires the complainant to give notice within 6 months of being aware of the injury. The fact that the complainant doesn't know, can't foresee the future as to the full ramifications of this harm has generally been held not to excuse the failure to give early notice. How do you respond to that? I mean, the district's conduct occurred at one time, I guess, when it set up this alley. It hasn't. There's no other additional affirmative conduct that the district is charged with in terms of causing the implosion of his wall.
Well, Your Honor, I disagree with that respectfully. The claim is that the district improperly maintained the alley over a period of time. So unlike
well, it's that they neglected to fix it. I mean, I don't know that there's anything more than the district failed to correct the drainage problem.
Well, and I think, Your Honor,
that it created.
Well, I think it is a question of ongoing maintenance. What I would say, Your Honor, continuing tort context, what happens is that, as time passes, failure to maintain the alleyway, to maintain it, does effectively create separate damage and separate cause of action. Now, in the Ross or Brown cases, for example, in the Brown case, Your Honor, there was a specific failure to diagnose alleged, abdominal injury based on plaintiff who was incarcerated. That failure to diagnose was a one-time event, and the condition that the plaintiff had sort of gotten worse over time, but it was all related to that one failure to diagnose. And also, I'd say in the Ross case, lead paint, again, what happened is that the plaintiff goes to the hospital, hospitalized for 5 days, knows she has, or the mom knows her child has lead poisoning. And if she gets a neuropsychological test years later, there was no additional ingestion, lead paint, everything derived from that initial ingestion and diagnosis. What we have here, Your Honor, is an ongoing failure to maintain the alley over 30 years. To fix this in 1985, 1990, 1995.
Yeah, I mean, I'm wondering whether that ongoing inaction to the alley constitutes the equivalent of a continuing tort.
Well, Your Honor, certainly.
Or some other
failure to maintain can constitute a continuing tort. You have an entity, whether it's a private party, state, has an ongoing obligation to maintain the safety of its roadways, the safety of its alleys. I'm not sure this was an additional design problem, Your Honor, for the alley. I think it's just a failure to maintain time, whether same way with roadway, perfectly fine for years and then start to deteriorate and sag. And
So to get back to a question that Judge Fisher asked earlier, let's assume in 2001, the damage to the property created by the drainage is so great that Mr. Farris recognizes that the property is uninhabitable and goes to the trouble of hiring an engineer to put up some sort of steel beams to shore up the property so that it doesn't collapse. But let's assume he does nothing in 2001 when he does all those things to give the district notice, and he doesn't file suit within 3 years of that event. You think that it's consistent with the purposes of 12309 to say, well, all right, so he waited another 17 or 18 years and the wall collapsed, and then he gave notice to the district. And he should therefore be allowed to bring a claim for his damages. General principles seem to suggest that the district expects notice promptly so that it can, when a person who is injured realizes that they've suffered injury and realizes and is aware of the district being the cause of that injury. It sort of seems odd to think that this belated note 17 years later, when the wall finally collapses, is timely, doesn't it?
well, I mean, I think the district would have a better argument if Mr. Farris had never provided notice until January of 2016. But once he provided that notice, at the very least, he should be able to make the claim for his injuries for the 6-month period prior to that. But your honor scenario is not our facts. Actually, Mr. Farris provided notice in 95, 91, 92, and 99. So he provided prior notices basically each time there was some.
Well, now I've been wondering how much that helps him, and this gets to your continuing court theory, because while he provided notices, while he may have provided notices in all those years, he did not follow up with a lawsuit within the statute of limitations. So there's a question in my mind as to the significance of those prior actions, even assuming, which is, I take it, an issue that would have to be resolved on remand if we get there, even assuming that the notices complied with 12309.
Understood, Your Honor. I would say that Judge Rigsby, in his April of 2019 opinion, addressed continuing court through a reasoned analysis and said, basically, plaintiff attempting to establish a continuing violation must demonstrate a continuous and repetitious wrong with damages flowing from the act as a whole, each individual act. And so based on that standard in Bolton International Education, second 499, the court was persuaded that at least for summary judgment purposes, that Mr. Farris had raised enough of an issue to preclude summary judgment on that point, Your Honor. And I think that
it is not statute of limitations. Can I just give you a variant of Judge Glickman's question and see what you think of it? Imagine that what happened was that your client bought the property, and when the first time there was a rainstorm after the purchase, the water went running off, and it collapsed the basement, and all that was left there was rubble, and he couldn't live in it. And he never used it thereafter. He never gave notice to the district. But in every further, and then 20 years go by, and the rubble, the paint is chipping off the rubble, and because water continues to leak, and it continues to do, minor damage to the rubble. is it your view that he could have filed, he could file a notice the day after, a little bit of rain, and he sees that the rubble is kind of damp and a piece of paint is chipped off the rubble, peeled off the rubble because of, the most recent rainstorm, and that his notice would be adequate to leave aside statute of limitations questions about what he could recover as a matter of statute of limitations law, but that his notice then would be adequate to bring in, if the statute of limitations would allow it, everything that went before all the way back to the first rainstorm after your client purchased the property?
I think at some point, Your Honor, I think theoretically that could be possible, but at some point would not be a sufficient factual issue to.
I don't see. I'm trying to phrase it so let's say it's undisputed that 2 weeks before the final notice there was some leakage that it was 98% collapsed and rubble, and another little piece of rubble fell off. So there is some damage sustained, physical damage to the property was sustained, although the property had been unusable and largely a heap of rubble for 20 years. So I'm not sure what the factual issue is. That's a legal issue, really. I think about notice. I'm trying to give you all the facts. So if those are the facts, what's the legal answer about whether a notice on that, within 2 weeks of the last little piece of rubble falling off due to a rainstorm, would be adequate to permit suit if the statute of limitations would, with respect to all of the injury that was sustained over the prior 20 years?
Well, and we're assuming the statute of limitations would allow suit.
No, I'm not. I'm saying don't worry about the statute of limitations. I'm asking you a question about how to interpret the notice provision.
Okay, so
the notice provision is not a statute of limitations provision. So
I understand that.
If your answer could be yes, that's adequate notice, I might have trouble on statute of limitations. That's a fine possible answer. But I'm trying to separate the statute of limitations issue and just ask you what you think, how to interpret the notice provision.
Understood, Your Honor. And I think the answer to the question on just a notice provision, I fully understand the statute of limitations is a separate issue. On just a notice provision, that would be adequate notice as to some damage or.
No, I thought your argument is it's as to all.
Well, I think that.
Is all a continuing tort, or does it matter like when the bigger pieces of damage occurred, or, because that gets you into tough questions in this case about how much, there was obviously some damage earlier. And I thought you were saying I thought your lead position, not your fallback position, was your notice, 6 months after the basement collapse embraced everything that went before on a continuing tort / notice theory.
That is correct, Your Honor. So let me clarify that. And I feel like I'm back in law school and it's fun, but I want to make sure I understand the hypothetical, which is that leaving the statute of limitations aside, I think if there was some damage or injury sustained within that 6 month period, that would be sufficient notice to bring a lawsuit under 12309, but that doesn't address all the statute of limitations issues we might have to face on that. Now, I do have that fallback position, sort of the Motley Ivy position, which is that the 12309 might end up cutting off your claim 6 months before that first notice. So, I do think that there would be damages issues involved in figuring out the statute of limitations arguments, and damage generally. There's all.
Counsel, I'd like to ask you a question about your motion for leave to amend your complaint.
Yes,
you
sure.
wanted to add a count to alleged a physical taking. Do you argue that 12309 would not apply to such a complaint? Or how does that get you out from under the 12309 ruling, if that ruling is correct?
Well, Your Honor, I'm not aware that, I do think I'm not aware that 12309 applies to constitutional claims. I don't think this court has gone that far as a whole.
Well, the statute talks about unliquidated damages, and those could arise from standard torts or constitutional claims. So I'm wondering why the statute doesn't apply to a constitutional claim.
I mean, I think that's something your honors would have to grapple with. I'm not aware that it does, or it's been held to apply to that extent, because I think the Constitution trumps state law generally, so a U.S. Constitution. But I would say, Your Honor, in this case, Mr. Farris provided a notice in January 2016 relating, and his takings case relates to the implosion of the alley into his house in 2015. There was no claim of takings when he might have had some seepage into his drywall or something like that. I think the real essence of the takings claim under Arkansas Game and Fisheries Commission is really that when there was an implosion of the alley into his house, there's effectively an inverse condemnation without the government officially taking the property. And that occurred in December 2015. And there wasn't.
So you think that injury occurred at a different time than the ones we've been talking about thus far?
Yes, Your Honor. That injury occurred no earlier than December 2015.
Okay.
There was no allegation that there was any cave-in into his or implosion at a time prior to that. His house may have had leakage, there was water, but the actual damage, I think at that point was really where the inverse condemnation becomes an issue.
Thank you.
Okay, let us hear from the government, and then we'll give you a few minutes in rebuttal.
Thank you, Your Honor.
Thank you, and may it please the court, Tyler and Treyer for the district. My friend on the other side would have this court ignore ample evidence in the record. Mr. Farris was aware he had suffered an injury long before 2015. And I think it's important to focus the court again on precisely the arguments that Mr. Farris has advanced on appeal in his opening brief. Because Mr. Farris's lone argument preserved in his opening brief is that he suffered an injury in December of 2015 when his foundation wall failed, and that he provided timely notice thereafter. But as the preceding discussion noted, there are multiple significant events, all of which indicate that Mr. Farris sustained an injury well before 2015.
May I ask you a question? Ms. Chair, may I ask you a question? When the statute says the injury, what is the injury? How do you define the injury?
The injury here is the initial water that leaked into Mr. Farris's basement, and that's by his own account in his counterclaim, the theory on which he is proceeding with that counterclaim.
Why is it he didn't suffer? Why is it he can't say, oh, yeah, I suffered a small injury back then in 1980 when water came in. It, stained the walls. I had to get a mop to wipe it up from the basement floor, but I didn't think that much of that. I suffered a much greater and different injury when the wall caved in. That's a different injury. Why is that not the injury? Why is it he can't, for example, say, look, I've suffered a series of injuries from the district. I'm not complaining about all of them, but this is the one that I am complaining about, and I want to give you notice. It happened. Why is that not the injury for purposes of the statute?
It's part of the same injury, and that's by Mr. Farris's own theory. And I'll just note that all along,
what makes it the same injury? If I could, this is what I want to get clarity on. What makes it the same injury? A person looking at this would say, "Whoa, wet walls are one thing. A collapsed wall is another thing. It doesn't seem the same."
Well, unfortunately, I think that's the consequence of not acting on water leaking into your basement for nearly 4 decades. And this court has made very clear that lack of awareness of the full seriousness of an injury does not excuse.
Right, but I think that's a little off topic. I think we have to kind of Well, let me ask you an antecedent question even yet. Do you think there's a difference between injury and damage in the statute, so that really we should be talking about damage and injury as physical injury to people, or do you think they're pretty interchangeable for our purposes?
I mean, for our purposes here, yes, to the extent there's any difference. Mr. Farris hasn't asserted there is.
Okay, so that's helpful. We have to just figure out, like, when the keywords are the injury or damage. So I'm going to use damage because property damage seems more intuitive to me for this. But so when the damage was sustained, so those are the key statutory terms. And in a very simplistic sense, it seems like if I have a basement and on day one, it looks like, it's got some, paint and staining and things. Our case is worse than this for Mr. Doomer's client, but just take a slightly simpler case. And then a bunch of water runs off, and next thing I know, I have a collapsed basement. If somebody said, what's the damage? It's like my basement collapsed. When was it sustained? On the day it collapsed. And you're saying that's not right. And I'm just, like, what's the theoretical construct? How do we tell when something that looks like a discrete, more aggravated thing that happened on a day has to be treated instead as the further manifestation of an earlier injury? That strikes me as just a really interesting, difficult, unclear inquiry. And so I'll give you some hypos and you can tell me what you think of them. So here's an example. Imagine I live next to an intersection that the district has designed, and it's a dangerous intersection. And I know it's a dangerous intersection. In fact, a year after I live there, I am in an accident where somebody, because of the danger, hits me and I get hurt. And I, go to the doctor and I get some, medical treatment and all that, and I suffer some damages, and I don't give the district any notice, and I don't sue the district. And then, like 5 years later, I have another accident, and I get a completely unrelated injury. And this is, again, it's easier, different from our case, completely different injury, same negligent conduct or omissions by the district, but it manifests itself, both injuries to me manifest itself twice. I assume you would agree that I could give notice promptly after the second incident, and I wouldn't be barred by having failed to give notice about the dangerous condition after the first injury / damage, or do you think otherwise?
Well, so there are a few things in Your Honor's question. I want to make sure I address them all. First of all, I just want to push back a little bit. Mr. Farris has always used the term injury, so I just want to be clear that insofar as there is any difference.
Okay, I'm happy to use the word injury. If everybody agrees nothing turns on it, then feel free to use whichever one you want, and I'll do the same.
All right, thank you. I just wanted to be clear about that. I think Your Honor's hypothetical presents obviously a much more difficult question than what's presented here. Well,
I was thinking it might be an easy starting point to harder questions. So
then I'm in trouble. But
no.
I think
or I may be quite wrong. So either way,
I think in Your Honor's hypothetical, there's a personal injury, and then there seems to be perhaps a negligence theory that drawing causation to the district's roadway. But I'm just not sure how probative that is as compared to this case where.
Well, I mean, you may or may not think my hypothetical will illuminate anything. That's a fair opinion to have, but I hope you'll try to answer it anyway. And so I'm just trying to figure out if you, what I'm trying to illustrate with that is, would you agree that a single dangerous, singular continuous negligent situation created by the district's acts or omissions sometimes will result in damage or injury that are not the same, and that therefore the failure to seek relief with respect to the first of those doesn't bar a timely notice and trying to seek relief with respect to the second. So that the key to whether the injury is sustained on a day isn't simply it arose from a single continuing known pre-existing type of negligence. Do you agree with that? That's the abstract question I'm trying to get at.
I think in the abstract that may be possible, but I think that the court has to proceed first with the inquiry. When was the claimant put on notice, either actual notice or inquiry?
Well, no, the statute doesn't say anything about notice. The statute says when is an injury sustained? And my question is, if I am driving through an intersection on a date and I get hit by a car and I was fine and my car is now damaged and I am bleeding, it seems to me that I have a hard time thinking whatever other circumstances you think may be true about what the claimant knew or what had happened to the claimant at the same intersection in discrete incidents in the past, whatever the answers are to those questions, the answer to whether the injury was sustained, what date the injury and damage were sustained, is the date of that second accident in my hypothetical. It sounds like you're not so sure.
Well, I'm not so sure because, again, the notice question, as the court has explained in the Barnhart case, the court has construed the statute in terms of whether there's inquiry or actual notice. And as I believe it was either Judge Fisher or Judge Glickman noted earlier, there's several instances in the record here where we know that Mr. Farris was on actual notice. I mean,
okay, well, let me give you what I think was a simpler hypothetical. Imagine that I move next to an intersection and I know it's dangerous and I know that the district is responsible for designing it in an unsafe way. And I see several people have accidents. And I never give the district, I never say, hey, district, you've designed a dangerous intersection that I live by, you need to fix it. And then, 7 years later, I'm driving through it and I get hit as a result of the negligent design of the intersection. On what date was my injury or damage sustained?
I mean, I'm not sure in that hypothetical that at the first time that the individual noticed the roadway that that individual would have incurred an injury. If later on that individual proceeds on a suit to recover damages for personal injury. So I think in that case, the mere existence of the roadway and a suspicion that the roadway is dangerous, it may not be probably most likely in that case, a cause of action would not have accrued. And
although this is not this statute isn't a statute of limitations provision, and accrual of the cause of action is a separate inquiry, distinct from the different wording of this provision. So it may be an analogy, but it's only that.
Yes, but I think if we're speaking in terms of injury, I guess maybe as a sort of a shorthand way of just noting that I don't think that that individual just noting the existence of a roadway would have suffered injury if that individual goes on to sue for physical injury, down the line. But of course, here the original.
I'm going to ask one more hypothetical, I promise. So, imagine that I buy a house that is next to a district-operated sewage plant, and imagine that a year after I buy the house, there's a kind of a little leak from the sewage plant onto my property, and it causes me some. It damages my property. Causes me economic injury. I have to clean it up and it kills a tree or whatever you think of, but it's minor. And I don't give the district notice about it. I don't sue. It doesn't seem like it would be worth pursuing. And then imagine that based on the same negligent design of the sewage plant, 10 years later, the holding tank completely collapses and my entire property is just deluged with sewage and my house is, damaged. You would say, so it's like different pieces of different parts of my property are injured. You would say the failure to give notice from that first minor leak would preclude timely notice under 12309 relative to that big, damage to more of my property years later. Am I right in understanding your position?
I think at the very least, it would depend on the theory on which you're proceeding. And here, and Your Honor noted in that hypothetical that there would be different pieces of the property affected, different damages in those different places. And But here, what we
Well,
have is
I'm not sure. I know you think this case, that hypothetical is different from our case, but I'm not sure I got what your answer is about how you think that what the notice answer would be under that provision.
so I think if
I'm sorry, I said that provision under that hypothetical.
yes, under that hypothetical, if I think at the moment that the individual has notice of the injury, then the section 12309 requirement kicks in. And if the injury asserted is the injury that the sewage had been leaking from the water plants all along, then yes, notice would be required upon first noticing that leakage. If the potential claimant's theory is quite different, there's been leaking on one side of the property and maybe 5 acres away, as your honor posed in this hypothetical, that there's some explosion of a different tank and it, the leakage, flows down a hill and, overtakes a barn. If that, it may be that the original leakage noted, is not part of the same injury that's a part of the individual's claim. And so the notice requirement may be different. But again, that is very, very different from the case that we have here, because there aren't such difficult questions as in your honor's hypothetical. Mr. Farris has claimed all along that water has leaked into his basement, and he's also always diagnosed that as attributable to the district. And he's essentially waited 4 decades to pursue that claim. And he's hired a structural engineer, as the court has noted, in 2002 to install additional steel bracing to support the foundation. And in his January 2016 letter, he has characterized his property as totally uninhabitable since 2008. And so where Barnhart says there has to be a total lack of awareness of injury, that is not what has occurred here. And I wanted to also point out that my friend on the other side has raised a number of arguments for the first time, both here at argument and also in the reply brief. And so, for example, there is no law of the case issue with respect to a determination about a continuing tort. I believe what the trial court said was that it had speculated as to whether the continuing tort doctrine would make it, quote, likely the damages could be recovered in a certain situation, but that was not a definitive determination either way, such that there would be some sort of law of the case issue. Of course, the continuing tort theory would go to claim accrual in any event, but I just wanted to clarify that for—
Can I ask you, and this may be something you were getting at in an earlier comment, but I just want to see if I can make it crystal clear. One point that your opponent has made at argument today, a line of argument, is even if the notice that was allegedly sent and allegedly not received in January of whatever year it was, I'm blanking on it, was too late. There was adequate notice given at earlier times that could keep this lawsuit alive relative to a notice claim. Did I understand you correctly to say earlier at argument today that you think that wasn't adequately briefed in this court by Mr. Dumar and therefore is not properly in front of us? Is that what you were saying?
Yes, exactly, Your Honor. That I think the first time that Mr. Farris makes mention of the adequacy of those earlier notices is there's a mention in his reply brief, and of course that would have had to have been raised in his opening brief. And so, it's just simply not the case. And we note this in our opening brief that he has not relied on those earlier instances of correspondence as his notice of claim. He has only ever maintained that this January 2016 letter served as his notice of claim. I'd also note that clearly there would be a statute of limitations problem in any event were he to rely on those notices. And so, there are multiple avenues to affirming the trial court. We, of course, believe that he suffered an injury beginning in 1980. But again, even if this court were to disagree, it's very difficult to ignore the fact that he took the affirmative step of hiring a structural engineer, that he thought that his property was uninhabitable by 2008. And to conclude that to ignore that evidence and to rule in Mr. Farris's favor would go directly contrary to this. It would directly contradict this court's cases in Brown and in Ross. And so I understand that those are the failure to diagnose cases, but they are very similar in that these are two cases where it's difficult to ascertain the exact moment of injury. And so setting aside if this court disagrees with the government that that as Mr. Farris maintains, he began suffering an injury in 1980, setting aside if the court were to disagree, then these cases would certainly dictate that the fact that he hired the structural engineer and that he represented to the district later on, supposedly that his property was completely uninhabitable, then certainly that is indicative that he had not only inquiry notice, but actual notice that he had suffered an injury dating back to 1980.
And what is, I think, unnerving about the district's position is that it doesn't matter how trivial the initial injury was in comparison to the later injury, in your view.
I don't think that's the case. And I think conversely, Judge Glitman, what this case demonstrates is that failure to provide timely notice could lead to a litigant essentially sleeping on their rights for 40 years and then seeking to bring suit against the district. Moreover, in this posture,
it's funny. Yeah, I take that point, although it's a little hard to feel all that sympathy for the district here, because in point of fact, the district did know about the problem in the alleyway for a considerable period of time and did nothing to cure it. So the notion that, oh, poor district, it gets surprised by a belated notice, all right, I take it as a general principle of law, but it rings a little hollow, you know?
I mean, respectfully, I would disagree, Your Honor. I mean, I know that that's Mr. Farris's contention that the district had actual notice all along, but the court has been very clear in explaining the purposes behind Section 12309, that it's one, to promote public safety. It's to make sure that the district is aware of and can conduct robust investigations and preserve relevant evidence in a timely fashion. And of course, the relevant evidence here would go back to 1980 by Mr. Farris's own account. So there was every incentive for Mr. Farris to submit a timely notice of claim by his own account. The first time he submitted notice was 5 years after he first noted the damage to his basement. Just to Judge McLeese's earlier point, the counterclaim.
But what do we do with the notion that, the statute fails to make that clear? If you're just a naive citizen and you look at the statute and you're in Mr. Farris's position, years have gone by. Yes, you didn't notify them about the minor drainage problems. You didn't even notify them. This is a weakness in his position, granted. You didn't even notify them about the need to shore up the wall with a steel structure. But you look at this and you say, look, all I have, there's an injury I'm now complaining about, the collapse of my wall. And I'm giving you notice of that. That's all the statute seems to say. How does a citizen know, a citizen who's not a lawyer and doesn't, understand about our case law and all that kind of stuff, how does a citizen know that, oh, I can't give them notice about this collapsed wall because I didn't give them notice 30 years ago about the fact that it was staining my basement and I had to buy a new mop?
I take Your Honor's concerns about the potentially harsh results of strictly construing 12309. I note in several cases, including the concurrence of the Brown case, this court has noted that inevitably sometimes there are harsh results, particularly for the claimants who are bringing wrongful death and survival claims. But those potentially harsh results did not prevent strict construction of the 12309 notice requirement.
Well, my concern ultimately is not so. Yeah, my concern ultimately is not so much that there are potentially harsh results, although that's a concern, but that we've gone around and around, and I don't feel like I know I have an answer to the question of what constitutes the injury. within the meaning of the statute?
The injury here, I think the court can very easily point to Mr. Farris's own characterization in his counterclaim, is the water leaking into his basement.
Okay, so let me just make sure this is not a hypothetical. Well, I guess this is sort of a hypothetical. So maybe I'm backsliding on my representation I wouldn't ask for. But imagine that what happened was that, in 1980, after Mr. Farris moved into the property, he noticed that water was running off the alleyway and was doing minor damage to his basement. So, a little staining and whatever it was. And imagine that promptly after noting that, he wrote a letter to the mayor, which the mayor received, that said, "Dear Mayor, you have a badly designed alley. It has caused some water to leak into my basement." And then imagine that 30 years go by and the district doesn't respond to that. And water keeps leaking in, and eventually the whole house collapses, and he sues the district 30 years later. Am I right in understanding that your view is no need for any further notice about any damage on any other day because he gave a notice, in 1980? Is that the logical consequence of your argument, and is that your position?
I mean, assuming that he had submitted adequate notice.
Yes, a notice that complied with the requirements of 12309 substantively.
Substantively within 6 months of noticing that injury, then I presume the notice requirement would be satisfied, but there would of course be a statute of limitations.
Well, no, there wouldn't. Well, maybe there would. Maybe there wouldn't. I'm not sure, I guess. But it's funny because that reading, when the district's alleged negligence occurs on date X, and the knowledge of the claimant about that injury, about that damage, negligence occurs on date Y, and some minor injuries are occurring on date Z, and I'm running out of dates. And then that's all too minor, and no suit is brought. And then ultimately there's like big damage and something terrible happens. The purposes of the statute, if notice has to be given at one, either it's at the end is fine or at the very beginning, whatever you do, it's not going to work well to meet all of the purposes of the statute. Because if notice in 1980 would have been enough here, so he wouldn't have had to tell the district, "Oh, you might want to come out and look at my basement that's collapsed because I'm about to sue you, and for lots of money relating to this collapse." The district would have wouldn't have any knowledge until 6 months later. And so some of the kind of evidence preservation components aren't met if early notice is what is required and adequate. On the other hand, if you wait until now, like in a case like ours, where you wait till the very end, if that's what was done here, then the notice at the end doesn't really give the district an opportunity to correct, or so that when these things get pulled apart, a major manifestation of further property damage and the underlying negligence in the claimant's knowledge, there's really no way of fully meeting all of the statutory purposes, it seems like to me. Do you agree with that, or?
Well, not necessarily, but what I think your Honor's question is getting to is whether there's the point at which there's actionable injury, and that is an argument that Mr. Farris seeks to advance that this court has squarely rejected. And
you mean actual knowledge?
Actionable injury.
Oh, actionable.
Actionable injury. So I think another way of understanding his argument is that I said there was this injury. Now, in retrospect, I think it's de minimis compared to this, greater, more catastrophic injury that I've incurred. And so I think this is a different way of getting at incorporating the discovery rule, which this court has already rejected in Dunmore and other cases. And, in the Ross case, this court said, we have already rejected an actionable injury type theory. And where we have cases where the exact moment of injury might be difficult to pinpoint, we can at least look to the worsening of the condition. And as we've discussed at length here, there are several moments in time where we can very easily ascertain a worsening of the condition, either 2001, 2002, 2008, and so forth. And all the upshot of all of that is that there is not the total lack of awareness, as this court requires in construing 12309 and Barnhart and the other cases. And so as a
But
result,
unlike some of our other cases, in this case, the thing that caused the injury, the drainage, didn't all occur back in 1980. I mean, this is not a case in which we're simply seeing a delayed sequelae of the causal agent. It's rather that the district has continued to leave the alley in the condition that it's in. Maybe no overt actions on the district's part, but the point is the draining is continuing all those years. And one would have to say that, well, you can't say that the collapse of the wall, for example, was due to the drainage that had occurred up to 1980. Rather, it's the continuing drainage for the next 40 years that led to the collapse of the wall. Does that make a difference to you in terms of the notice requirement?
So you cut out for 1 second. I just want to make sure that I'm understanding Your Honor's question. Does it make a difference the amount of time that passed in the alleged inaction?
In other words,
by the district,
let's take one of the hypotheticals. Maybe I can tweak it that Judge McLeese used. Next to Mr. Farris's house, there is some sort of sewage plant, and in year one, the sewage plant does leak a little, and it gets onto the soil, and it does some damage. Mr. Farris doesn't complain about that. Now, over the next 20 years, the district continues to operate that sewage plant, and it continues to spew out all sorts of stuff that's leaking. Some years it's worse than others because that's the nature of the beast. And 20 years, after 20 years of such leakage onto Mr. Farris's property, which he's not suffering anything in the interim from it, but the result is that his soil is poisoned and his dog dies and all his trees die, and the house is declared I forget what it's called, a federal environment toxic waste remediation project, and he has untold damages as a homeowner. Your position seems to be that although the damage he suffers in years 20 is the result of what the district did in years 2 through 19, his failure to give notice in year 1 precludes him from pursuing a claim against the district for the damage that the district inflicted in later years. And that's what this case is, because this is a case where the drainage, which is attributable to the district, the district didn't make it rain, but the drainage is attributable to the district, was stuff that occurred in the follow-on years and built up over time. Your position, though, I take it, is that the statute requires that year 1 notice. If the district had that year 1 notice, they might have cleaned up their act and we wouldn't have years 2 through 19. I get that hypothetical. And so notice in year 20 when the damage to the property when he becomes aware of this really serious damage to the property is not adequate. And that's your position, I guess. And I have trouble. I mean, it's a position. I can understand the argument. It's one, ultimately, you could say, ongoing cause, the ongoing day-to-day, day-by-day infliction by the district of injury in a drip-by-drip way, you could say. But I wonder why that means there's only one injury for purposes of 12309.
Well, Judge Glickman, that conclusion follows directly from this court's having held multiple times, a lack of full awareness of the seriousness of the injury doesn't excuse giving notice. And I think what Your Honor described is actually on all fours with the Ross case. And the court there said that notice was required prior to understanding the full extent of the lead poisoning there.
Yes, but there the difference is that all of the harm, now if it is a difference, maybe it's not a difference. I take it that the Ross case points in the direction supporting your argument, but there is a difference. In the Ross case, it's not as if after that initial lead poisoning event, the child continued to be poisoned by more lead over the next umpty years. It was one discrete poisoning event, and the sequelae took some time to manifest. But the complainant knew about the poisoning, was aware of it at the time, knew about the possibilities, and suffered some injury immediately, namely the medical care and so forth. So I just wonder whether this is a different situation because the injury is being inflicted over time.
I mean, it's not a different situation in that in the precise moment, if this court thinks that the precise moment of injury is very difficult to ascertain, then the Ross case and the Brown case directly answer that question. And the answer is that notice would have been required upon a substantial worsening of the condition, and notice was not given. And moreover, the statute of limitations would have run, which is an alternative basis for this court to affirm.
I'm proving myself a serial false promiser because I do have one other scenario I'm interested in your reaction to. Imagine that what had happened here is that at the time of the basement collapse, someone had been down in the basement and had been killed by the collapse of the basement. Am I right in understanding that your position is that an action against the district would be barred by the failure to have given notice in 1980 of the leakage that caused some staining in the property?
That may be the result, and harsh though that may be, I think that this court has always made clear that Section 12309, that strict compliance is required and bars claims for unliquidated damages. And so, but I think there may be other factual issues there in that hypothetical. So I can't give a definitive answer right now, but to sort of take a step back, in general, we understand that the statute is to be strictly construed, notwithstanding harsh results that has prevented wrongful death and other similar types of claims from moving forward in situations where the moment of injury was difficult to ascertain. And I think, the court has posed a number of difficult hypotheticals this morning. And I appreciate that there are some much more thorny factual variations. But on this record, in this particular case, I think it's very straightforward for the court to affirm the trial court because you have so much evidence in this record. Mr. Farris himself noting the injury, diagnosing it, always attributing it to the district, and then these very significant events where there's no way to conclude anything other than that he had notice of the worsening of this condition at the very least. And so in view of the only argument that he's advanced in his opening brief on appeal, that his injury was suffered upon the failure of the foundation wall and that he gave notice thereafter, that claim must fail. And for those reasons, we would ask that this court affirm.
Counsel, thank you. Mr. Dumar, we'll give you a few minutes in rebuttal.
Thank you. Briefly, Your Honors, in our opening brief, and I think this is the right position, that Mr. Farris's notice on January 2nd, 2016, discussing the partial collapse of his home, it alleges an injury or damage, actually alleges a damage due to the negligent maintenance of the district over time. That's a injury or damage defined under 12309. And he's complied with that statute. The district had separate notice of the problems in the fall of 2015. Now, the district, in its opposition brief, basically argues, as it did today, Mr. Farris should have provided notice earlier. Well, even in his January 2nd, 2016 letter, he notes attachments dated 1985, 91, 92, 1999, and 2002, where he wrote to the mayor earlier. And Judge Rigsby, part of the record, in his opinion, notes this the record that's up before the court, the opinion that's up before the court, that defendant mailed Mayor Marion Barry a letter in 1985, and then 4 more letters to the mayor's office complaining about the state of the alley at later times. So yes, he suffered different injuries, and he let the mayor know each time, but his first notice was in December 1985. So even if for some reason, which I don't believe the case, that his January 2016 notice was inadequate, Your Honor, rebutted the district's position in its opposition that somehow he should have provided earlier notice, because he had. But I think, going back to Judge McLeese's example, or one of the hypotheticals, I think here, and Judge Glickman too, there is an ongoing negligence to maintain. So it's a lot different than Ross and Brown, where either there was the one ingestion of lead paint or a one misdiagnosis that led to injury. Here, there is a ongoing negligence to maintain that's alleged that did lead to separate injuries. Mr. Farris properly provided the notice under 12309 in January 2016, but to the extent he needed to provide it earlier notices, he provided notices going back to 1985 to the mayor, Your Honor, and that's all on the record. Thank you.
Counsel, thank you both. The case is now submitted, and we can excuse you and you may log off.
This court is now adjourned.